Good morning and welcome to the 31st meeting of the Rural Affairs and Islands Committee in 2025. As usual, can I remind everyone to switch electronic devices to silent. Our first item on the agenda is an evidence session with the Minister for Agriculture and Connectivity to discuss this Crofting and Scottish Land Court Bill. And we've scheduled approximately 70 minutes for the discussion on Part 1, which relates to crofting reform. And I welcome to the meeting Jim Fairley, the Minister for Agriculture and Connectivity, and his officials. This morning we've got Michael Nugent, the Bill Team Leader and Head of Crofting Policy. Bill Barron, the Crofting Bill Team Advisor, and James Hamilton, the Solicitor. Before we start, I remind you that you don't have to operate your microphones. I'm quite sure you were aware of that. So I'll kick off. Minister, just would like some clarity on how the government will ensure that environmental use is clearly defined and actively managed to deliver environmental and community benefits, while also preventing neglect or indeed absentee ownership. Well, Jim, I should have said if you've got an opening statement. That's 2 weeks in a row I haven't given you that opportunity. So if you've got an opening statement, we'd be delighted to hear it.
I have indeed. Good morning, Convener. Good morning, Committee. And thank you very much for inviting me to give evidence on the Crofting and Scottish Land Court Bill. The bill, as you know, has two main parts, and I'd like to begin with a short opening statement on Part 1 for crofting. I'll give a further short statement on the merger of the Scottish Land Court and the Lands Tribunal for Scotland later in the session. The crofting provisions in the bill are the culmination of over 3 years of stakeholder engagement. To date, there have been 20 crofting bill group meetings, and these will continue through the upcoming stages. The proposals that have been considered come from a variety of sources, including issues previously identified by a crofting bill team in 2016 to 2019, many of which were drawn from the crofting law sump. Issues that the Law Society of Scotland singled out for crofting law reform in 2019 and 2020, and issues identified and raised by stakeholders over the 3-year period. Over the summer of 2024, we carried out a consultation and officials ran 15 public events throughout the crofting counties, which were attended by 257 people. It's fair to say that this bill has not lacked stakeholder engagement. It has been mentioned that the bill does not go far enough and that it does not address some of the bigger issues that exist. But this bill was never meant to deliver fundamental reform, a point that has been made by officials throughout this process. Crofting law is complex, and even where there is consensus that something needs changing, it is often difficult to reach a consensus on what the remedy should be. Developing proposals and identifying workable solutions requires time. But this bill is more than just a technical bill, it is also an enabling bill. It will give crofters more options in how they use their land. It will allow approximately 700 people to apply to become a crofter. It will streamline the enforcement of duties in the family assignation process and prevent those in breach from profiteering and removing land from crofting tenure. Landlords and subtenants will be able to report breaches of a duty to the Commission, and crofters will be able to apply to the Commission for boundary and registration changes. So the reforms should not be viewed in isolation, but alongside the work that is being done by the Crofting Commission. As the Commission pointed out in its evidence, it is important to note the interplay between the legislation and the Commission's policy plan. The legislation provides the necessary framework, and the plan provides the detail of how the Commission will administer and regulate. As advised by the Commission, it has both the legislative tools and now the resources to carry out its functions. And the changes in this bill will further support the Commission's work in processing regulatory applications and tackling breaches of duty. The bill prepares the ground for what comes next. It will help to lay a stronger, healthier foundation for crofting, where we aim to have increased residency levels and people more actively using their crofts and common grazings. And then we will be in a better place from which to take stock and consider what is needed for the future. And I'm happy to take questions, Convener.
Thank you, Minister. I think it's important on the back of your statement to put on record that almost universally from stakeholders there was a feeling that the consultation and the pre-legislative engagement has been very well received. That was from all the stakeholders. So that's the consultation and the work that your team has done behind the scenes is probably an exemplar and maybe something to work on with other pieces of legislation as we move forward. So I think it was important to recognise that. So my first question is, you'll not be surprised to hear, it's to ask how the government will ensure that environmental use is clearly defined and actively managed to deliver environmental benefits, but also ensuring that we prevent neglect and absentee ownership.
First of all, I'm going to absolutely concur with your opening statement. The Bill team have done a phenomenal job in that engagement. My entire period of getting round the Crofton counties when I was going out on my own, it was quite clear that they'd done a phenomenal amount of work. So hopefully that allows us to get the bill absolutely right. In terms of the question you've asked about environmental use, the bill is clear that environmental use must be planned and managed and for a clear purpose. It does not adversely affect adjacent land, and crofters are already familiar with the planned and managed manner. And that planned and managed and for a clear purpose is vitally important. We're sympathetic to the concerns that someone might neglect their croft and claim that they are simply rewilding. However, we also believe that it won't be difficult for the Commission to tell the difference between someone who is actively putting their croft to do environmental use, or being able to explain what the environmental benefits are and what they're trying to achieve with that, or from someone who is simply neglecting their croft and presenting the results of that neglect as good environmental practice. We have intentionally framed the provisions in broad terms to allow for flexibility and adaptability as the new environmental practices and technologies emerge. And we've taken note of the concerns raised by stakeholders and, as officials have already discussed at the Crofton Bill Group and the cross-party group meetings, will be strengthening the wording of the bill to avoid any misunderstanding of the policy intention. Those changes may be along the lines expressed by those who have already given evidence. For example, environmental use could mean any land that is deliberately planned and actively managed to achieve a specific environmental outcome. Allied to this, the Commission explained in their evidence session that they intend to make changes to the policy plan, and that will help bring further clarity on the matter to explain what would be expected of crofters to meet that specific duty. And the legislation provides the framework, and the policy plan provides the detail for how it will be implemented and enforced in reality. But the land is the key asset, and we need to optimise its use, whether it's to produce food more sustainably, whether it's to cut emissions, or it's to enhance the environment. There are 750,000 plus hectares of land in Crofton tenure, and that represents a significant opportunity in terms of dealing with some of the key challenges that we face for creating potential benefits for crofters.
Thank you. I'm very conscious I don't want to step on anybody's toes with further questions on stronger enforcement, but a lot of the concerns around the potential additional environmental use, we're seeing people at the moment not being pulled up for absentee ownership and neglect, whatever. But we're going to move on to that. One of the concerns we did hear during evidence was that one crofter could put in a plan to rewild or re-wet or do some peat restoration, which might have a negative impact on neighbouring crofts. So, for example, if there was a ditch that ran through a number of crofts and croft one decided to block it up to re-wet as part of an environmental scheme, it would be to the detriment of others potentially further downstream. Who will police that? Who will decide whether there's a detriment to other crofts?
Well, the thing about crofting is it's supposed to be crofting communities. So I would hope that the communities will work together. Anyone who's been in the crofting counties and croft communities will know that there are always a potential for difficulties. But that's the role of the Crofting Commission. So if we have those individual disputes, my understanding would be that the Crofting Commission would have a role to play in making sure that those disputes are agreed amicably for the benefit of the entire community.
Okay. Would you suggest that needs to be more formalised so it's quite clear in the legislation? Because at the moment it's not clear how conflicts over detriment to neighbouring crofts might be dealt with. Do we need to just spell that out a little bit clearer in the regulations and the legislation?
No, the Commission have significant powers at the moment, but if that needs to be strengthened, then I'm quite happy to go to Bill or to Michael to say, is that a position that we would need to be looking at?
Yeah, I mean, that is something that we have been talking with our environmental colleagues about, and we do think that some of this will be able to be covered in the Commission's policy plan to be able to kind of put some flesh on this, provide the detail, so that crofters know what it is that they can and cannot do when it comes to this duty, and how the Crofting Commission will actually enforce it.
Okay. Would that extend beyond just the individual in-byland crofts and actually to the common grazings when a decision was taken?
Well, the policy plan will include everything that's to do with crofting, so I would presume that yes, that will have to be considered in part of the common grazings as well.
Okay, thank you. Alistair Allen.
Briefly, on the back of that question, Convener, about some of these scenarios about crofters having a debate about what happens on in-by land, would you continue to foresee common grazings committees having some role in managing these kind of situations? I appreciate we're not talking about common grazing, but is that part of what you would anticipate their duty to be?
As in the Common Grazings Committees? Well, they will have to work with their local community and the Crofting Commission to ensure that what they're doing is working for the benefit of the individual crofters as well as for the crofting community.
Okay, thank you.
Okay, do you want to continue?
Okay, thank you. I'm going to have to check with you, Convener, which area you had in mind. Are we talking about 8?
No, on to
2.
Enforcement.
Enforcement, yeah. Okay, yeah. Thank you. So one of the themes that's come through regularly in all our conversations with the crofting communities, and I'm sure in yours as well, has been the appetite for more enforcement and more regulation, which doesn't often happen in other sectors. But how will you ensure that the Crofting Commission is resourced to step into situations where it needs to step in and find a resolution, whether that resolution is reletting a croft, or whether it's finding a subtenant, or whether it's other kinds of interventions to avoid situations where crofts are simply abandoned?
It's a very good point, and I meet regularly with Gary Campbell, who's the Crofting Commission's Chief Executive Officer, and the Chair, Andrew Thin. And we discuss crofting and the Commission's performance. And those two topics are always high in the agenda about enforcement duties and the regulatory application and processing times. So the Commission is increasing its enforcement work. I think that has been very clear. Last year, through taking some form of regulatory action, they've commenced engagement with 215 crofters and they've resolved 134 breaches of duty. And the level of engagement and enforcement is increasing further for this year coming. Since the summer, the Commission is terminating tenancies at a rate of 1 per week due to unresolved breaches of duty. And that's significant. You can see that the Commission are actually now using the powers of enforcement that they have. And as advised by Gary and Andrew in their evidence session to the committee, the Commission is better resourced than it was a few years ago. It's already taking greater action to enforce annual notice provisions. And as Andrew Thin said in his evidence, the Commission already has the legislative tools to enforce duties, and it is through the crofting census. And if the census is not returned, the Commission will now be taking action. If the census is filled in falsely, then that's fraud and action will be taken, and spot checks will be carried out on those that have returned their census. So for many years, the Commission has been supported by ARPID offices when proper local knowledge is required to advise on regulatory applications. And more recently, ARPID has also been acting on behalf of the Commission in connection with the duties and enforcement cases. So we're using the existing network and local agricultural offices in this way because it's a more sustainable, and it's seeking to establish a parallel network of local Commission offices. This bill will help further through streamlining of the enforcement processes and the family assignation provision and the enforcement provision against subtenants and short leaseholders, and that will enhance the efficiency and scope of the Commission's enforcement functions. And I think there are quotes that Gary Campbell gave to the committee about the level of enforcement that they're carrying out now, which wasn't happening in the past. So I hope that gives the Crofton community the confidence to know that the Commission are actually using the powers that they currently have through the extra resources that were put in a number of years ago.
So you mentioned cooperation with other organisations like ARPID. This is something, again, that's come up in evidence. It's related to this issue because it's about enforcement. Can you say a bit more about how that will work? Because quite a number of stakeholders have given evidence to this committee, directly or indirectly, looking for ARPID and the Crofton Commission to work more closely together when it comes to gathering evidence about activity or inactivity.
Well, ARPID are the people on the ground in those local areas. The Crofton Commission can't be everywhere. They've got the powers of enforcement, and using that local knowledge through the ARPID offices is clearly beneficial, because, as this committee knows better than anybody, actually being on the ground and knowing what's happening locally is probably one of the most important things that we can do in order to make sure that the Crofting way of life and the Crofting townships are actually functioning in the way that they were designed to do. So it's using that local knowledge and that local resource to be able to allow us to ensure that Crofton is functioning properly.
And finally, Convener, you mentioned streamlining, and I think what you focused on there, if I heard you right, was potentially the Commission spending less time dealing with assignations, more time doing other things. So can you explain a bit about whether there are other areas of the bill which allow the Crofton Commission to focus its activities into new areas?
Well, the assignation thing is probably the biggest one, because that was the vast majority of their time that was taken up. But Bill has worked in the Commission, so do you want to give a kind of brief overview of the things that would eat into time for the Commission?
Yes, I think there's lots of things in the bill that will actually speed up different aspects of the Commission's work. I mean, for example, the ability to make changes to maps. At the moment, if there's a mapping problem, that can cause a great many exchanges of letters and eventually, land court processes and so on. And the bill proposes to introduce a much simpler way of making changes to maps of crofts when that's required. The assignations, as the Minister says, is a big one. There are other things in the bill as well which will just simplify and speed up processes. But I think the other key to this is that the process for enforcement itself is being streamlined and sped up, so that for the amount of resource you can put on enforcement, you can get through more cases. Plus the fact, as the Minister said, that the resources did go up a few years ago, and the Commission now are benefiting from that, so the backlogs have come down, and you're able to see more resources going in, fewer distractions from elsewhere, and a quicker process when you are doing enforcement. So it all adds up to quite a significant change.
Okay, thank you, Convener.
Certainly, it was a strange situation where every other sector would demand less regulation, less red tape and less enforcement. Again, almost universally, the Crofton sector are looking for far firmer enforcement, more enforcement and potentially more regulation to protect the whole Crofton community.
I think that point that you make is actually very pertinent, Convener, because it's the Crofton community themselves that want this to happen, because they understand what their community is and the requirement to have that ability to be able to just say that this is a functioning ecosystem that we all live and work in, and therefore if people are upset in that, then we need to have that kind of ability to be able to intervene. So I think this is, and also the fact that the Crofton Commission have clearly demonstrated that this has now become a very serious matter to them. It's sending the signals out to those that have maybe been a bit lackadaisical in the past that this is no longer acceptable, and if the Crofton communities are going to work as they're supposed to function, then they're going to have to comply with the duties, and I think that can only be a positive thing.
There's almost certainly going to have to be additional resources, and I know Mr Barron suggested that reduction in the capacity required for assignations and boundary changes will bring around an increase in capacity in some areas. But from what we've heard, that there is a lot to do. There's a lot of concerns around abandoned crofts and those not abiding by the regulations. So we're going to need more active monitoring and enforcement. Are there any plans to use technology? So we had a suggestion that drones could be used, or LiDAR or whatever, to detect changes in the management of crofts. Is that something that would be considered to provide some of that capacity? And if so, would there need to be additional legislation to allow that to happen?
You're actually raising something that I haven't heard, Convener, but very happy to take that away and have a consideration of it.
Okay, thank you. Tim Eagle.
Good morning, Minister. So Section 3 makes changes to who can report suspected breaches of crofting duties, and now 2 new groups are added to that list. When we had the Crofting Commission in front of us, they said that anonymous reporting made no difference to their work, and that in their eyes anyone can allege a breach of duty provided they provide evidence. What is your view on widening the reporting of breach of duties to include anyone?
The anonymity bit, Michael, I'm going to ask you to deal with the anonymity bit just now.
Yeah, I mean, I think that is a difficult topic, and any views that I express is obviously only in this Crofton context. There are obviously advantages to anonymous reporting, and I think that's obviously quite obvious for the reporter. The overall disadvantages, I suppose one is factual and the rest are maybe a little bit more subtle, but in the legislation, the Crofton Commission must investigate a reported suspected breach of duty if it comes from one of the people, the organisations listed in legislation. So in order for the Commission to know whether it must investigate that report, it needs to know who it's come from, unless the report is frivolous or vexatious. So that's the first point, is that the Commission needs to know who is making that report. And I think that furthermore, and I think Gary Campbell covered it a little bit in his evidence session as well, is that in a small community, you're more than likely to probably to know who has done that reporting. However, I think that I know that if I was living in a community and somebody had reported me, you start looking around the neighbourhood, you start questioning your friendships and your relationships. You can quite easily make false assumptions. You're thinking, is it my neighbour next door who I get on very well with, but kind of covets my croft, or is it the person I fell out with a few months ago when it wasn't crofton related? So it's very difficult to know. So I think that can cause its own problems. And the third one, I think, as well, is the fact that if you are reporting something and you want to try and safeguard your identity, I think that the information you can give can be quite vague, and I think the information can suffer as a result. I mean, if I'm living across the road from somebody, I can't report if I want to safeguard my identity by saying, well, I live across the road from Mr Nugent and there's been no car in the driveway and his croft is overrun. So I have to be a little bit kind of cuter, a little bit more subtle with the evidence. I think sometimes the evidence can suffer from that as well.
Just to pick up on that then, because I think you just said there, if I'm right, that the Crofting Commission needs to know who's putting the complaints, but that's not. On the 24th of September, they said to us it would be quite content if anonymous reporting was allowed, and it would not make any difference to their work. So why are they saying that to us here, but you're saying something different now?
I'm pretty sure that Andrew Thinn, and that may be wrong, I don't have the transcript in front of me, but I thought that Andrew Thinn said in his evidence that because of the way in which the legislation is structured, that the Commission must investigate if it comes from the report comes from a Grazings Committee or comes from somebody within the Crofton community. So they need to know that in order to know whether they must investigate or not.
I wonder if the Commission was saying that they needed to know, but the question of anonymity within the community was one they had no view on. That Michael set out the reasons why we feel anonymity within the community is not a great idea either.
But they also stated that they would consider a report of breach of duty from outside those mentioned in the legislation, but they wouldn't then be required to do anything about it. You know, anyone could make an allegation, anyone could say that there is a problem with a croft somewhere, but it's only those that are within the legislation that they must then act on. So I think that's probably what Andrew Thinn was trying to get to when he was talking in that evidence set.
So you're quite content then that the 2 additional groups that you've put into the legislation under Section 3 expands it far enough in your mind?
At this moment, yes.
Yes, okay.
Thank you. Alistair?
Thank you. You mentioned, Mr Nugent, I think the other phrase, coveting thy neighbour's croft. So how do you cope, or what is the policy that you envisage to cope with vexatious or repetitive complaints of that kind?
I must confess, I don't deal with those reports. That's obviously the Crofton Commission. Perhaps Bill can provide what the Commission's position is on that.
It doesn't come up very often in that form. I mean, it's more often comes up at the point where a croft's being assigned, and you know, the objections come in. I don't want you assigning to that person because actually there are other people, including myself, who would quite like that croft. But the Commission's aware of that. It rarely comes up as a totally vexatious point, but sometimes it's a point that's made that doesn't actually go anywhere because it doesn't have very much legal force.
Thank you.
Sorry, James.
So there's a provision in the bill as well that allows that supplies the Commission's duty to investigate if they consider the complaint as frivolous or vexatious as well, so they have discretion to filter those sorts of complaints out.
It's maybe a question for the Crofton Commission, but do you have any idea how many complaints they deal with on an annual basis, how many are actually investigated and how many turn out to be vexatious or not found to be valid?
Bill could possibly estimate it.
Just an estimate.
It's not a figure I'd want to mention now. It's a couple of years since I left the Commission.
Okay, what's
we could potentially get that figure to you. We could speak to the Crofton Commission and ask them to furnish the committee with that.
I'm sure it will be in our papers somewhere, but it would be quite interesting to understand that the sort of numbers we're looking at and the challenge that there might be ahead with the change in legislation. Thank you. We're now going to move on to our next theme on Crofton Commission powers and questions from Beatrice Wishart.
Thanks, Convener, and good morning, Minister. This is about Section 8 and the three croft limit. We've already heard about the streamlining of family assignation, the family assignation process. And we heard in evidence from NFUS that they noted that the 3 croft limit could stifle active crofters in areas like Shetland due to different patterns of land ownership, and they suggested a flexible, regionally sensitive approach or applying the limit only to family assignation. So my question is, how will the Scottish Government ensure that the fast-track process balances the need for administrative efficiency with the flexibility to account for regional differences in croft sizes and patterns?
Okay. Crofters have got the right to assign their croft, but it's only with the consent of the Commission. The legislation sets out the process that must be followed before the Commission decides on the application, and that includes public advertising and the opportunity for local crofters to object. In the case where a crofter wishes to assign to a family member who may already be resident in the community, our position is that this is a disproportionate process. It costs time and money for the crofter and the Commission, and we want to reduce that burden of the Crofton regulation where it makes sense to do so. And this is one of the things that came out of my trip around the Western Isles in particular, where they talked about family assignations. So the Commission resources freed up with this change will then be available for the Commission to deploy elsewhere, when we were talking earlier on about reducing the burden on the Commission to be able to carry out more enforcement duties, for instance. We settled on 3 cross because that felt like it struck the right balance between policy intention, which is to improve the efficiency of the service provided to customers, and the concerns that this could result in croft collecting or land banking by certain individuals. And the main reasons for not going with a hectarage threshold is that we are including any interest that the crofter has in deemed crofts, and that doesn't have a set hectareage. It's normal and accepted for some crofters to run business on multiple crofts, and we're not opposed to that in any way, shape or form. But it's also beneficial to the community if there's opportunities for new entrants to take on a single croft. And all we're saying is that if you have 3 crofts or more, your application will then be subject to the current process, and the local community will be given the opportunity to comment on the Commission, will give a reasonable consideration. But there is no one crofting area that is disadvantaged by using the 3 croft rule. This is just about, we want to make family assignation as easy as possible, but if you have 3 crofts or more, then it's worth having another look at that, just to make sure that there's fairness in the community.
So there is a degree of flexibility, is that what you're saying?
In the sense of?
In the sense of the 3 crofts within a family?
It's not a definitive, if you've got 3 crofts, then you can't get any more. That's not what we're saying. What we're saying is the Crofting Commission would then take a look at any further assignation if you have 3 crofts or more, but that doesn't mean to say that the Crofting Commission would say, no, that's not allowed, you can't do that. It's just to make sure that there's the appropriate spread of the number of people within a crofting community, and one family or one person doesn't just keep gaining a croft and gaining a croft and gaining a croft, and land banking, as I said before.
Okay, thank you.
Tim Eagle for a supplementary, and then Rhoda Grant.
I think, Minister, you may have actually just answered my question. I was looking through the consultation responses in relation to this, and I think various crofters picked up concerns about croft size not having been considered in this, Dean Cross being double counted, disadvantaging people with multiple small holdings. And actually, I think the Shetland participants particularly noted it was quite normal in Shetland to have more than 3 crofts locally. Yep. So I guess it's that I think you've answered that point, but actually this is not about stifling economic growth or sustainability of a croft, but actually just making sure that there is fairness across the system. Is that what you're saying?
That's exactly what we're saying. We're not looking... One of the things that definitely came up, particularly in the Western Isles, was that assignation process for family members, to make that as simple as we possibly could. But that couldn't then result in, a particular family hoovering up the entire area. Yeah. So this is just about the Commission being able to say, right, hold on, you've got 3 crofts, let's just have a look at that and see, are we in the right place? But that doesn't mean to say that the Croft Commission would then say, no, you can't go any further.
Okay.
Can I perhaps just add some figures to that? Is that we've got 14,489 crofters and 13,196 crofters have 2 or fewer crofts. So it's 91% of crofters could be the recipient of the family assignation, as long as it's a family member that's assigning it to them. So that's 91%.
That's helpful. Rhoda Grant.
Just a small supplementary to that. In the past, we've seen crofts being subdivided quite often, especially when there's several family members and people are wanting to leave a share of the croft. Would that be taken into consideration if someone had 3 or more crofts, if they had been subdivided in the past? So bringing them back together again might not count against people?
Now you're getting technical, and I want to pass that one to Michael.
That would be included in the count. If that individual is registered in the Register of Crofts for having that croft, because that will be where the kind of count comes from. So if they are registered to that croft, then it will count, yes.
Okay, so it could be tiny pieces of land we're talking about.
I mean, I don't want to second guess what the Commission would do in these circumstances, but I'm guessing that what would happen if you've got somebody who has 3 or more crofts and they're working their croft, they're meeting their duties, they return their annual notice, an assignation application, so it's their 4th croft, has to go through the normal process. I'm sure that the Commission will treat that assignation application in much the same way as they would today. It's just that it has to go through that process that it currently goes through. That would be the only difference.
And I presume that if the croft has been subdivided and created to be a croft, therefore it would have to be counted as a croft. Because if you don't, how do you then, would you have to re-amalgamate these crofts to make it one croft? It could get very, very messy. So I would presume that the Commission would, as Michael say, look, without putting words in the mouth, favourably on anybody that's got 3 crofts, as long as it's meeting the duties of what it is we're trying to achieve.
I'd like to know about the division application in the first place, that if the division application would create tiny parcels of land that are too small to be a viable croft, then the Commission would refuse those in the first place. So you know, what you've got is a system with viable crofts, and therefore applying the 3 croft rule kind of makes sense.
Okay.
I think, Minister, you certainly suggested that you recognise that croft sizes do vary greatly and widely depending where you are in the country. So Donna Smith obviously pointed that out, but suggested that a regional discretion might work, which seems to be a sensible suggestion. Is that something that we would need to have in the face of the bill, or is that something that could be dealt with through guidance?
I'm not sure that that's needed, but Michael, I'm going to pass to you and get your consideration on that.
I think if the provision as we currently have it worded remains in the bill, then I don't think that we could stray from that. But I had a quick look at the figures, and I'm pretty confident that these figures are incorrect, but we can provide these figures to the committee if you give us another kind of couple of weeks. But we had a look at the regional areas and where people have 3 or more crofts. For example, in Shetland, if you decided that you were going to have a different system in Shetland, that would benefit 338 Shetland crofters. But you also have 645 Highland crofters that are in the same boat. So, and there'll also be, there's over 200 in the Western Isles that have over 3 or more. So if you're going to start having different rules for different regions, you're going to have some people in the Western Isles who would like to benefit from the rules that exist in Shetland or the rules that exist in Orkney. And I think this would very much complicate this process. This is a process where it will benefit, it will streamline the process, it makes it more efficient. But if you have 3 or more crofts, the process is just simply the process that crofters go through today and have been going through for years. And I think that the final decision that the crofting makes will be on the strength of what the local community says, if it says anything. And I think it will obviously look favourably on any crofter that is using their croft, meeting their duties and completing their annual notice.
But I suppose, you know, from what you say there, it would appear that one rule doesn't necessarily fit all when we look at the differences in crofting in Shetland and maybe in Skye. Would there be anything wrong with setting something out that said, given the regional variations in crofting, and we want to achieve a good outcome, that there can be recognition of those differences?
I think the difficulty with that is how you would actually do it. I mean, Donna Smith's point said, you know, when there are small crofts, wouldn't you want a larger number? But actually, the place where people have been calling for a variation on this isn't the Western Isles, where the crofts are small. It's come more from Shetland, where the crofts are larger, but it's slightly more common for people to have multiples of them. So how would you actually go around doing that and say, you know, which is the area that I mean, this is a small adjustment. It's whether to not introduce a fast-track process and continue with an existing process. So it's not people being handed out, you know, gold rewards for this. It's a fairly small thing. And to go into the business of, you know, let's have a slightly different rule for one area rather than another, how would you then justify to the person who is exactly the same type of crofter to the one in Shetland or the Western Isles or Argyll and say, well, no, you can't have that slightly different privilege because you happen to live in a different area? That I think would be quite hard to do administratively.
Okay, thank you. That's helpful. And I get a question about community-led croft acquisition. So how will stage 2 amendments to section 10 ensure that community-led croft acquisitions, including rural housing projects, are allowed?
Sorry, could you ask that question again? So
the stage 2 amendments to section 10, which in our evidence was alluded to by the Crofting Commission, how will amendments to section 10 ensure that community-led croft acquisitions, So that includes the likes of rural housing projects. How will we be assured that they're going to be allowed?
Okay, this is a legitimate concern, and officials have raised this at the recent Crofton Bill Group and Cross-Party Group meetings, and we've begun discussions with stakeholders to try to resolve it. So we will potentially looking to amend this, but Michael, I'll pass to you to give some background to what the discussions that you've had.
Okay, thank you, Minister. I should maybe begin by saying that we haven't actually discussed this with James and his colleagues yet in SGLD, but how this could be delivered should be, or could be, relatively straightforward. So, if an owner-occupier crofter sells their croft to a natural person, the owner-occupier crofter status will transfer. So that's fine, there's no change there. That's okay. But the way in which that we have it worded in the bill is that if an owner-occupier crofter sells their croft to a non-natural person, that transfer becomes null and void. We don't think that should be the intention. What we should have is a system where if an owner-occupier crofter sells their croft to a non-natural person, the title can transfer and they would become landlord of a vacant croft. But the owner-occupier crofter status would not transfer. So that would mean that local community body could become the landlord of the croft, and then they can decide who gets that croft. And that addresses, we think that addresses all the concerns that have been raised on this.
Okay. I know we had a lengthy discussion at the previous sessions on this. So it's reassuring to hear that you don't think there's going to be any issues with that. I've got the next question is Beatrice Wishart.
Thanks, Convener. This is about Section 14, the Commission's powers to adjust boundaries. And we heard in evidence concerns from legal stakeholders about the possible conflict with title boundaries, and it could create disputes. So how will the bill ensure alignment between the Crofting Register and the Land Register while allowing practical boundary corrections?
Okay, the bill gives the Crofting Commission the 2 new powers to resolve registered croft boundaries problems when all parties are in agreement. The adjustment will be possible for simpler cases where no land is brought into or out of Crofting tenure, and boundary remapping will be possible where more complex boundary changes are sought. Where there is so we've taken the boundary adjustment concerns on board, and officials are in discussion with the Registers of Scotland and the Crofting Commission to address them. We acknowledge that it's often important that the title extent, as shown in the Land Register, aligns with the occupied extent, as shown in the Crofting Register. The boundary adjustment process will give crofters whose boundaries have become unaligned the option for how to remedy the position that they find themselves in. And we're looking at various ways in which to ensure that the boundary provisions consider the linkage between these 2 registers. One possible suggestion is that we allow the Commission to award provisional consent to a boundary change, but that would be subject to the necessary conveyancing, and that would amend the title on the Land Register. But we will address these concerns that have been raised, and we'll look to amend the current provision accordingly.
I mean, we did hear in evidence from Brian Inkster that his view that the proposed provisions are a recipe for disaster.
As I say, we're looking at various ways, we're looking at we've listened to the concerns that have been raised, and we're looking at ways to allow us to be able to get this right. Is there anything you want to add, Michael?
No, just to say that the suggestion that the Minister just explained there, we think that that will address the concerns that Brian Inkster raised.
We did hear from other stakeholders that currently the Crofting registered boundaries are inaccurate, and that there would need to be tighter procedures to improve registration boundary amendments. Does the legislation need to go further?
I don't think so. I think what it is that we're doing looks to try to resolve the issue that has been raised, unless there is something that either Bill or Michael want to add to that. I think what we're looking at here is a fix to the potential problem. Bill?
No, I would agree with the Minister there. The bill's introducing two things. One, a power to make corrections when the boundaries in the crofting register are wrong. And the second one, an opportunity for a crofter or a landowner to apply to make a change that it isn't wrong, but it's just inconvenient and be better to be somewhere else. The first of those is probably the slightly more difficult. Let's make a system whereby the Commission or the Register of Scotland can just change it and make it right. We think that would only be used in cases where it's absolutely self-evident and clear and agreed what the correct answer is, because as soon as you're into disputes about boundaries, the only sensible place for those to go is the Land Court.
Okay, thank you very much. Now going to move on to our next theme, which is common grazing, and got questions from Rhoda Grant.
Thank you. The bill stops the accidental severing of common grazing rights from crofts, but it does nothing to stop the deliberate separation, so someone could reassign their croft, but not assign the grazing share that goes with that.
Okay, crofting laws are unbelievably complex, as this committee knows better than anyone. And common grazings and the associated shares are probably the most complicated part of that. The policy intention is that there shouldn't be any accidental or unintended separations of shares from the Inbye croft, and that's something that broadly everyone agrees with. We have listened to the views and the concerns expressed by stakeholders before and during the evidence sessions, and officials have set up a grazing subgroup. They've already met on 2 occasions. It's made up of crofting lawyers and Scottish Government Legal Directorate to resolve some of the concerns, and they are working on the following topics. I'm going to pass to James because we're definitely getting into the legal side of things.
So, I mean, Section 15 creates a presumption that the grazing right will be transferred as a default as a pertinent of the croft land. But since the introduction of the bill, I think you've heard from legal stakeholders that there's, I think it would be fair to say, there's a lack of certainty as to the relationship of the grazing right with an owner-occupied croft, and particularly whether that grazing right can be characterised as a pertinent. So, for example, there's a 2012 Land Court decision which says that the grazing right is a pertinent and can be transferred in a disposition of the croft if it's expressly included. But on the other hand, the Land Register don't include grazing rights as a pertinent, which they would be required to do if they thought it was a pertinent under the Land Registration Act 2012. So we've been engaging with stakeholders through the Crofton Bill Group to try and identify the appropriate mechanism by which the grazing right can, as a default, be attached to the owner-occupier croft when that's transferred. But to answer the specific question, that would still allow intentional separation of the grazing rights. So we are working with stakeholders, and I think some of the stakeholders have alluded to this, to identify the appropriate mechanism to ensure that accidental separations don't occur, to identify an appropriate mechanism which will demonstrate the link between the Inbye croft and the Dean croft, and subject time allowing and the development of it, to see if we can identify a process by which grazing rights which have been accidentally separated can be reattached to the Inbye croft interest. So these are issues that we are aware of, that we recognise in the bill, and that we're working with stakeholders to identify the correct solutions for. So I'll pass back to the Minister.
So by finding the solutions to these issues, we hope that, and I think we will alleviate most of the legal concerns that have been expressed, and we will make the necessary amendments to the bill as we go forward. But there are also policy concerns here, because we know that some stakeholders and crofters would prefer that the share always remained with the Inbye croft and could never be separated. But the concern is that that might lead to many more common grazings not being used at all, at least for extended periods of time, because historically it wouldn't have been an issue as most crofters kept livestock. And, that's no longer the case. Currently, if we were looking at this just now and 80% of crofters had livestock, we wouldn't be having this conversation. In fact, if 50% of crofters had livestock, we probably wouldn't be having this conversation either. But I think what we're looking at the moment, they estimate the figure to be around about 25%, and that's been decreasing over the years. So it's not hard to imagine that a township where all the crofters are meeting their in-by crofter duties, but none of them are using the common grazings. And in that context, I don't think there's a justification for insisting that all the shares remain attached to the crofts in all circumstances. What we think is that the decision should remain a matter of choice for the crofter, and many crofters will retain a share with a croft, but others have got no interest in the share whatsoever because they may use their in-by land purely to grow food and not run livestock at all, or they have no intention of using it. But we have listened to the concerns. We think that the process requires a safeguard, so we're also looking at establishing an agreed approach whereby a crofter, tenant or owner-occupier would have to apply to the Commission to divide a share from the croft, and they would have to state a reasonable purpose for doing so. We should trust that the Commission to then regulate that and ensure that the right balance is struck between the shares being in the hands of those that will actually use them and protecting against too many shares being separated from crofts. When discussing deemed crofts, we often start with the assumption that they are a bad idea. But the more important question is, are the shares in the hands of people who are actually going to use them? In their evidence session, the Commission correctly pointed out that a deemed croft can create an opportunity for a new entrant and their family by way of an appointment. And the officials are currently looking on whether we can amend the legislation to allow those that have apportioned their deemed croft to have all the rights that would allow them to work as a croft, including being able to decroft a small area of land for a house site. So the purpose is there to create that functioning community that we talked about right at the start of the session.
I can't quite understand why somebody would keep a grazing share and not have a croft. And it seems that this has happened by accident rather than design. But now we're coming to a point where people are looking at carbon trading and looking at forestry, looking at peatland restoration and the like, where suddenly the share in the common grazing could become very lucrative. So you could be a dead hand on a community, have nothing to do with the community, have no croft there, but have a grazing share that you then use, preventing the crofters within that community using that grazing share. And even when you're talking about going back to the 3 crofts maximum, there's nothing to stop you then assigning your in-by 3 crofts, but keeping all the grazing shares, which would give you access to a lot more land. It seems that it's kind of going against the stated aims of the bill, that you don't try and keep the grazing share with the croft and try and reunite them where they have become separated.
Michael, do you want to pick this up?
Yeah, I think the point that the Minister made is really important here, is that we have got crofters who are meeting their duties for their in-by. So they're living within 32 kilometres and they're using their in-by. But they've got no intention of using their common grazings. It's not within their plans to use it. So the ability to be able to pass that share on to somebody else we think is beneficial. And when that share gets passed, so it's classed as a deemed croft, they can apportion that. And then so it's kind of fenced off so that they're able to use it. And as the Minister said, we're actually looking into whether we can actually amend the legislation further, and so we've got an apportioned deemed croft to have all the rights that would allow them to work it as a croft, but being able to decroft a small area for a house site. Now, that's something that we're just considering at the moment. Once again, we haven't talked that through with SGLD. So we're just saying that this should remain a matter of choice for crofters, as it currently is. I think that if we make the changes where they have to remain permanently, I think that we have to accept a few things, and those would be that we're taking an existing right away from crofters, and that we would also be closing off a route that does actually create opportunities for new entrants. And I think the Crofting Commission said as much in their evidence session as well regarding the opportunities that this would create.
We're going to move on to more questions about deemed crofts and also the environmental use. But in the consultation, there was one question around this about the purchase of grazing lights and so on. but the question didn't actually probably allow the respondents to say exactly what we've heard in evidence since then. So over a third of respondents to a question on purchase of grazing rights suggested there needed to be more legislation around it. And many of the respondents called for automatic grazing rights to be included with the parent croft alongside a call for deemed croft to end. Now, we understand why the legislation would stop the inadvertent separation, so effectively a solicitor and not doing the job properly. I think we could say that, where they didn't recognise grazing shares were part of the croft. However, respondents did say there was a disadvantage of deemed crofts, and it was limiting the rights and crofting activity of the crofter, the risk of ownership of grazing shares becoming concentrated and crofting communities becoming fragmented. Ideally, and this was the Highland Good Food Partnership said, ideally deemed crofts and grazing shares should stay with the parent croft. The loss of grazing shares may seriously damage the viability of a croft, especially where the crofter wishes to keep livestock. From my point of view, I can't understand, given what Rhoda said about the whole, the outcomes that we want from crofting legislation, why there wouldn't be legislation to prevent the splitting of in-buy land and grazing shares, particularly given, and we're going to move on to that in a minute, a potential economic value, which maybe wasn't there in the past because of the ability for carbon capture and things like that. So why are we not going further to stop unless there's absolute conditions, a bit like Michael and Judith suggested in splitting off a bit of land for a house or something like that? Why is there not an assumption just against splitting the in-buy croft land and the grazing shares?
Well, the accidental one you've already touched on, but there are some crofters who do not and have absolutely no intention of using their grazing share. So if there is somebody else who wants to use that grazing share and it can be put to better use, then that's the purpose behind it. Is there anything that I am missing here, Michael, that would help to...
Can I maybe be helpful to give you an example? And again, we heard this in evidence where you've got a non-crofter whose company needs to get rid of a £100,000 profit, the tax on that. So he seeks to purchase grazing shares on a 5,000 hectare hill in Skye, and it seems a pretty good deal. He can spend 100,000, and that land might ultimately be valuable because of what that land now can be used for, whether that's renewables, whether it's other uses. So that land would then be taken out of the crofting scenario, and it wouldn't actually help townships, it wouldn't help individual crofters, and potentially limit the viability of townships and crofts. Why wouldn't the legislation prevent that type of land banking?
Well, I think what we're trying to do is we're trying to establish an agreed approach whereby a croft tenant or owner-occupier would have to apply to the Commission to divide the share from a croft and would have to state a reasonable purpose for doing so. And we therefore have to trust the Commission to regulate this and ensure that the right balance is struck between the shares being in the hands of those that will use them and protecting against too many shares being separated from croft. So, there is a balance to be struck here. And if we go back to the position, I understand people's concerns because the Crofting Commission weren't enforcing duties or weren't doing I'm trying to be very polite here. They were not deemed to be doing their job appropriately in times past. That is not the position just now. I think the Crofting Commission is in very good hands at the moment, and people understand that what they're doing is the job of the Commission properly in order to find the right balance for the communities that they're working with. So I think that's kind of where we are at the moment.
Okay. The other aspect of this that I think will help is the changes that James mentioned. That in the past, it was really quite difficult to keep your deemed croft together with your croft because they were in different parts of different registers and they weren't visible. We're doing as much as we can to make those links absolutely public and evident, formally, legally linked, so that the natural way to transfer a croft will be to transfer it with its share. I think that will make a huge difference. We've had a couple of thousand accidental separations, and if you dry that up, then the picture will change. The other aspect we're looking at in this subgroup that James mentioned is making it easier to reattach a croft. So once we've worked out what are the legal forms of how you link a croft to its share, we'll have an approach, hopefully, whereby people can apply, I've got a croft, I've got a share, can I link them so that going forward they'll be together?
Okay, that's helpful, thank you. Alistair Allen.
Thank you, Convener. So I think the measures in the bill which seek to avoid the accidental situation of deemed crofts, shares and a grazing which are separated from a croft will be welcomed. I'm just trying to get a picture in my head of this scenario, a potential scenario you could have in a township where several crofts ended up without shares and common grazings. I'm just trying to get a picture of what government's view might be on what that would mean for any new entrant who did want to keep livestock in that village.
As in, would they be able to get an apportionment on a common...
Would they be able to graze livestock if half the available crofts, hypothetically, in a village had become separated from the shares and the common grazing?
So there's various ways that might be resolved. One is if they looked around for one of these separated shares and bought it. So that's not impossible. But there's also a role for the Grazing Committee who manage the grazing rights and will be aware of shares that are available and are not being used, and quite often there are loans of those shares for 1 year at a time. So there are different ways in which you might tackle that.
Thanks, and that's very helpful. Just to pick up on the figure that was quoted there about only 25% of crofters having livestock. I mean, I appreciate there has been a big decline in the amount of livestock kept. But does that figure take account of things like subtenancies or grazing agreements or indeed abandoned crofts to get to that figure?
That figure comes from the Economic Condition of Crofting report, which was published in 2022. And we do a report every 4 years, so we're due to do one next year. So what I can do is I can find a more up-to-date figure. We think that 25% will be roughly the same. That's based on the amount of crofters that claim on their common grazings. So anybody who can claim government grants on their common grazings, that's how we got the 25% figure. And having spoken to ARPID officers, I think that there might be a little bit of variation there, 1 or 2% either way, because there will be probably some crofters that don't claim but do have livestock. But the vast majority do. So, but I can get a more accurate figure for the committee.
Okay, I think it's already been touched on the potential implications of too many deemed crofts in any one township for the communal aspects of crofting. One of the purposes of crofting is, of course, retention of population. So would the government consider enforcing crofter duties on shareholders who don't have a croft, the primary one of those being residency?
Well, the Commission can already enforce duties on deemed crofts. Their immediate concern for enforcing duties on in-by crofts, because there are...
I'm talking about people who own a share in a grazing, but don't have a croft in that community.
Sorry,
I'm talking about, would the government consider imposing, or does the government, forgive me if I've got this wrong, impose the duty of residency on somebody who owns a share in a grazing in a community but does not have an in-by croft?
Well, the Crofting Commission already have that power to enforce that duty as it stands.
Okay.
Because this would clear up an awful lot, and some of the questions that we've asked prior to this wouldn't need to be asked. And it's absolutely the regulations around deemed crofting, deemed crofters, are exactly the same as a crofter who has in-by land, if you like. The regulations are exactly the same, and if they're enforced correctly, a lot of the scenarios we're talking about shouldn't exist.
Yeah, because the Commission can already enforce duties on those crofts, yes. Okay.
Also, Bill Barney, once or twice during the session you've talked about grazing committees having a role, but we were made aware that there's a lot of grazing committees either don't exist or are not functioning. Do you think this legislation will assist in reinvigorating these grazing committees that would appear to, from what you say, have to shoulder a lot of the responsibility in policing or facilitating, moving forward with this legislation?
So the bill's removing the most blatant bit of Grazing Committee policing, which was the one introduced in 2010, I think, saying they had to report on every crofter every 5 years. And that's been widely ignored and not enforced by the Commission, and we're getting rid of it. So that will be a bonus. I think for a Grazing Committee, yes, it's hard work and they're volunteers. It's about the balance of, the responsibility, but also the opportunity. And there are things in the bill which will give grazing committees more opportunities, for example, for peatland schemes and so on. So ultimately, I don't think it'll make a massive difference to volunteering to be on grazing committee, but the Commission itself is constantly trying to encourage that, as are other crofting organisations. And in recent years, we have turned the tide on that. So the figure had got a lot lower about 5 years ago and has recovered since then. And hopefully it will continue to go in that direction.
Okay, thank you. We've got one final question on common grazings and a supplementary for Marianne Burgess. Rhoda.
Section 18 broadens the use of common grazings for environmental projects. And I wonder what steps you're going to take to clarify the crofters' right to carbon, because, as we know, some landlords are saying that carbon is theirs, so that they sell off the carbon credits. But we all know that the peat and the trees and the grass on a common grazing are actually the crofters. So I wonder if you're going to take steps to clarify that in the legislation.
Okay, well, the bill provides crofters and landowners with a legislative framework to help them propose and take forward environmental initiatives on common grazing, and that will hopefully encourage crofters and their communities to have a much greater say in how the land is used in their area. We want to avoid a situation where crofters are unable to access the funding schemes and incentives to do the things that we're talking about. But as I understand it, at the moment, the legal ownership of carbon credits is still to be fully determined through case law. So I'm not sure that we're in a position to state in crofting legislation where the carbon rights sit at this moment, whether it's the landlord or the crofter. In the meantime, we would encourage crofters and landlords to start looking at joint ventures, to enter into joint ventures and to develop and secure shared solutions that benefit all the parties together. Because at the moment, as I say, we still don't know what the legal ownership of carbon credits is at this moment in time.
But the carbon belongs to the crofter. The trees belong to the crofter. They can cut them down. The peat belongs to the crofter. They've got a right to cut peat and burn it in their fires. The grass belongs to the crofter because they can cut it and they feed their animals with it. There is no dubiety on this. And it seems to me that this bill will be an opportunity to make sure that that is beyond any question.
Okay. If we get the absolute clarity that you've just stated, then we can come back to you. But my understanding at the moment is the legal ownership of carbon credits is still to be fully determined.
That's an update.
I think the list that you said there is correct. As I agree with you, the fact that that a crofter obviously can cut peat and plant trees, etc. But it's specifically to do with the actual carbon credits and who owns the carbon credits, and that's what we're unsure of.
So if the landowner decided to sell the carbon credits based on the forestry on a common grazing, and the crofter came and cut down the trees, they couldn't sell that carbon credit.
That's exactly why there should be shared community conversations going on right at this moment in time until we have the clarity.
I disagree, but I'll leave it at that.
Yeah, I think this was sort of highlighted as one of the potential unintended consequences of bringing a bit of legislation in that did absolutely address a lot of the issues that stop us moving forward, but needed to be brought in prior to the next piece of Crofton legislation, which I think the government have even admitted will be required, a bigger piece of work. But this could be a loophole which could be exploited between now and when further work on a future Crofton bill could be done. I'm going to bring in Ariane Burgess, and then Tim Eagle's got some supplementaries on this as well.
Thanks very much, Convener. Just coming on that question around the carbon issue, maybe that there's a case to be made for the work of Jill Roby and her idea around the public carbon trust, which could be Scotland-wide. It'd be worth looking into that. But I wanted to pick up a question around transparency and in terms of what's going on in common grazing committees. And as the convener said, in some cases, they're not really active, they're not really happening. But in some parts of Scotland, in the crofting counties, you have a situation where not everybody's part of that crofting community. There are people that are part of the community, but they're not involved. And something that I've picked up from talking to constituents is that there isn't a transparency around what's going on in common grazings, and they feel that things are kind of being done to them, even as they're members of the community. So I just wonder if there are aspects of this bill, and I see there are some things around Section 16 is requiring public meetings to appoint the Grazing Committee, so there's and notify the Crofting Commission. So there's something there, but something that we could have more transparency about the activities of the Grazing Committee and what's happening on the land. And I also wonder if these grazing committees in some cases will fall under the new legislation coming in with the Land Reform Act and the land management plans, and that could help in that case.
So is the transparency that you're asking about, is that in relation to the grazing committees and what they're actually doing on the land and others don't know?
Yes.
Okay, well, you've touched on an area I genuinely don't know about. We can take that away and look at it. So you're talking about the wider community, not the crofting community?
Yeah.
Okay. You've touched on
so
something.
there are situations in parts of Scotland where people don't know what's happening on land that's neighbouring them, and it's crofting community that's doing it. That's just what's happening with the land use patterns now.
So the crofters have the right to the land, and the neighbouring community want to know what the crofters are doing.
Yeah, and I think that's a general direction of travel we're trying to go on, isn't it? More transparency, communities. It's kind of what the Land Reform Act was bringing in, that there's more transparency, that communities know what's happening on land around them. And in this case, it might be a grazing committee. Yeah.
Okay, we can take that away and have a look at it.
Thank you.
Balance, I'd just say grazing committee is a voluntary role. It's hard work. There's not massive reward in it, and a lot of bureaucracy around it. It would not be the right way to go, but we'll look at that.
Yeah, I mean, I think maybe there's something in there where you've got a situation where you've got grazing committees, but you've also got volunteer organisations that set up development trusts that are doing a lot of work as well and doing amazing things. So, and that's hard work. So, yeah, something to look at.
Okay, thank you. Tim Eagle.
Thank you, Convener. Minister, I've just got a couple of questions. Can I just firstly on this around carbon projects and that, because I think there is a valid point here, isn't there? And actually, I remember when I was working, I did some work for a wind turbine on Scottish Government land. Actually, I probably should declare an interest in that, where it was quite significant volumes of money actually that we were giving crofters, where a wind farm was going up, and then the crofting tenancies got the. I'll let the minister just. Feel free to get some water. It's that time of year, I think. I think the big question here, and I think it has been got at a wee bit, is are you conscious that what we don't want to happen is there to be this speculative buying or coming into of land in what we might deem crofts or hill land just because the value in these, in potentially the carbon markets in the future, and that would ruin the whole ideology of what crofting is to the Highlands and Islands. Does that make sense?
Yeah,
Absolutely. And very, very conscious of the fact that that is a potential area of concern as we go forward. But it's also a massive opportunity when you consider the sheer scale of crofting land that has the potential to help us with our environmental desires, what we're trying to do as a country. So we will definitely take a very close look at it. But until we have that clarity about what the legal ownership is, then that's, it's something we're just going to have to keep an eye on.
Okay. And then can I just come back very quickly to deemed crofts again? So I was aware of an example, I think on Jura, where there is one person that has 6 deemed crofts, but is considered absentee, and loads of other people in that area that would like access to that or need access to that ground, but can't get it. Is that something you're prepared, obviously there's been a lot of questions today, are you prepared to have discussions with us in advance of stage 2 and 3, just to see if more could be done around that within this bill?
Happy to engage with anyone who wants to talk to me before stage 2. There's absolutely no question about that. In terms of if you're talking about 6 deemed crofts where the owner of the 6 deemed crofts is absent, then they're not fulfilling their duties. That will be up to the Crofting Commission to make sure that we're fulfilling their duties. Okay.
It's just, I think, good to have that on record, and I'll email you separately or send it to you separately. Just to pick out on section 32, it's under the additional section, I think, of that. You are removing the necessity to have a landlord representative on the Crofting Commission. And I think there's been some concern, I think SLE brought this up during our round table, as to why you're doing that, particularly because actually increasingly moving forward, it is likely that actually landlords will be community bodies as that goes on. So can I just ask, why have you felt the need to do that at this point?
Well, we recognise the importance of the landlord's voice, and the bill continues to recognise that as well. However, there are normally only 3 appointed commissioners, and these appointments only come round every few years, and there's maybe other skill sets which are even more important. So we're going to retain the flexibility to make the best appointment, and the bill will provide that Scottish ministers must consult the Commission on the desired attributes for somebody who is going to be on the Commission, but also having regard to the value of the Commissioner who can represent the landlord's interests. So the Crofting Commission, and it is a commission, it's not the Crofters Commission anymore, they've got to consider all the regulatory applications and in drafting their policy plan. So the board has a responsibility to be able to consider all relevant parties, including the landlords.
So it's not your intention, because I think there would be that worry, wouldn't there, that by adding this section in, that it looks like you're not interested in what the landlords are saying. So just for the record, that's not your intention here. You still value, whether that be a private landlord or a community landlord, which increasingly I think it will be, and they've still got the ability to be on the board. It's just that you're taking out that requirement.
Yeah, it's taking out the requirement. Bearing in mind the Scottish Government are also landlords. So yes, there is absolutely no desire to water down or dilute the ability of landlords to be represented, but it's just in this circumstance there may be other more effective uses of that place on the Commission.
Okay, fine. And then just 2 very quick final questions. It's just around, again, looking at the consultation responses. I think you mentioned this in your opening statement, but there was this kind of response that sort of said this bill just doesn't quite go far enough. And there were 2 aspects of that I picked up on. One of them was quite a lot of crofters saying that the escalation in the market for crofts and tenancies, and actually what does that mean, new entrants, etc., being priced out. And then actually coming on to that point, and I think this is something we actually share, is actually how do we get new entrants into both crofting and farming, but specifically for crofting today, the bill just doesn't really go into that. Is that something you feel you've missed, actually? Is this a missed opportunity? And no. How do you respond to those people who said this bill doesn't go far enough in those to that extent?
No, I think this bill was always deemed to be a technical bill that was going to fix some of the anomalies, like that assignation for family members. So we've done a number of things that should allow us to be able to get the kind of outcome that you're looking for. The enforcement of duties is a really important one, because by doing that enforcement, it's meaning that people who have been willfully inactive and not dealing with their crofts, there will be circumstances where they just won't come back. As I already stated earlier on, I think there's a croft a week is being re-let by the Crofting Commission. that is creating a sense in the Crofton communities that actually this is now beginning to work and function in the way that it's supposed to. That's largely down to the excellent efforts of Gary and Andrew Thinn. And with this assignation, this simplifying the assignation of family crofts or two families, I think that is going some way. Is there more to be done? Absolutely. There's always going to be more to be done. But the bill as it stands at the moment is it's meeting the objectives that it was set out to do way back, long before I was a minister, when they started to talk about this. I think it's meeting those objectives, but it's also added one or two things that will allow us to try and re-stabilise that Crofton community spirit.
Do you think that is a fair comment? My understanding was that people were expecting this to be more than a technical bill, but you always felt this was only going to ever be a technical bill.
My understanding is this was supposed to be sorting technical fixes.
Okay. And just that point on new entrants then, away from the bill, I mean, we can have this discussion obviously between stage 1 and stage 2, but have you got anything in mind, whether in primary legislation or what might follow, that would encourage new entrants into crofting? Well,
as you know, we brought in a programme for government commitment to make sure that every local, every public owner of public land, that would include the Scottish Government and anyone who has crofting land, to look at the opportunities to get new entrants in. So, you know, it's something that, as you well know, I am very, very passionate about, making sure that we get a vibrant new generation of young folk coming into the industry, whether it's crofting or farming, and I think we're taking the steps to make that happen, and we're starting to see the results.
I ask because it came up in the consultation responses significantly, so I think it's worth mentioning. Thank you.
Thank you. We're going to move on to the next theme, which is the Crofton Register, and questions from Emma Harper.
Thanks, Convener. Good morning to you all. Good morning, Minister. I'm just going to look at the Section 21-25. There's been no concerns raised around these sections, which is about simplifying the governance of the Crofton Register and the Register of Crofts. So that's good news. And then Section 26, it expands the powers for correcting errors by allowing the keeper to fix clerical mistakes at any time. And I think, Mr Barron, you kind of alluded to that when we talked about mapping and the digitisation and things like that. So I know that Brian Inkster mentioned in his evidence that he thought we might be opening a can of worms, raising concerns that allowing post-registration amendments to the Crofton Register could create legal uncertainty. Any thoughts about Mr Inkster's evidence that he submitted?
Well, we've taken on board the comments from stakeholders, including Mr Inkster, and although there is almost full support for this provision, there's 93% in the consultation we're supporting this provision. Officials are already in discussion with the Registers of Scotland and the Crofton Commission to ensure that the legislation cannot bring about the scenario outlined by a solicitor in their call for views in the evidence session. But, Michael, do you want to pick this up?
Yeah, thanks, Minister. So there's already a condition in the bill that the Commission must contact all parties that have an interest and that are affected by the rectification. And the Commission must have regard to any representations that they make. So in the scenario laid out in the call for views, we don't think that would happen, that scenario, because the third party in that scenario, the one that has built a house on the disputed land, I think was what was stated, that would actually, they would be able to object to the rectification as they would be deemed to be an interested party. So the Commission would not take forward a rectification in these circumstances. And where there are disputes, that will always remain for the Scottish Land Court to resolve. So where there's a dispute, the Crofton Commission will not take forward a rectification.
Okay, and one of the additional issues might be that land that was excluded, that might now be added to a croft, would be part of this rectification process, would it?
Potentially, but once again, all the interested parties would have to be involved in it.
Right.
And the Commission has to contact all the interested parties. And as I said, they would have to have regard for any representations that they make.
And as you're saying, this is about simplifying the process to make it easier for boundaries, for instance, or fences or ditches to be added to a croft, for instance, that was maybe excluded before.
Yeah, I mean, that's obviously covered under the boundary provisions, changing boundary provisions. The rectifications is where there's been an error in the registering, and that corrects that. Where it's not an error, but a change is wanted by all parties, that would be covered by the boundary provisions.
Okay, thanks. Thank you.
We've now come to the end of part one of the bill, but I suppose it follows on from Tim Eagle's suggestion that a lot of stakeholders thought this was going to be more than a technical bill, and we know we had the SUMP report, which suggested more radical legislation to transform crofting and bring it up to date. So, Minister, can I ask you what discussions you're having, or when do you intend to start to look at implementing some more radical crofting reform?
Page 59. I have got it here. There was never an intention, excuse me, Camille. It was never an intention of this bill to deliver fundamental reform. It is technical in nature and it provides the necessary improvements at the same time as enabling crofters to take control over how they use their land. Excuse me. The future reform will absolutely be necessary, but I'd caution rushing straight into it. We first need to establish what crofting policy should be in the future, and some of the approach that we took with this bill. We need stakeholders to consider what that policy is, although it is ultimately the responsibility of government to set the policy. That should never be done in isolation. I think you referenced it right at the start of the session, how well this had been done by the officials, making sure that they were actively engaged with the stakeholders. So once we've got the views, we need to see where they converge and where the negotiation and compromise is going to be required. The last 3 years' worth of discussion has been very informative. It has led us to produce a bill that has wide stakeholder input and buy-in. But these discussions have also told us that there is a wide range of views out there. We can tell from the responses to the consultation that some crofters want more regulation, but there's an equal number of them that appear to want less. Some stakeholders are asking us to review a crofter's right to buy their croft, which is a perfectly reasonable question to ask, but there's over 6,500 crofters have already exercised that right. So establishing clear policy outcomes will take time, and it will be central to any future wholesale reform. I know from my travels around the country over the summer, we were getting different views from different sets of crofters, each absolutely valid in the concerns that, that they were raising, but there was a wide range of considerations that would need to be taken into any future policy programme.
It was back in 2018 that the government announced its intention to bring phase one of this bill on the back of many who believe crofting reform needed to be substantially reviewed and modernised. So this is what we've got. We've got phase one, which has in many ways simplified, corrected some less than perfect legislation. However, there is still the underlying desire that was set out in 2018 to make that radical reform. So what are the timescales for bringing that forward, given that it is quite some time, or now seven years since the government made the commitment?
Well, I would say what I said earlier on, that this bill gives us a solid foundation and a bedrock to go forward from. I'm not going to put a timescale now on when we're going to bring new legislation forward. We're coming out to an election next year, so there will be a whole load of things that will have to be discussed between now and then. But I absolutely take on board the point that you're making and that stakeholders have made, that some people would like to see the reforms go further. As I say, others want less regulation. So all of that would need to be considered as a policy objective, and it's very much in my mind for when we're looking to see what happens next year.
I think there'll be a lot of stakeholders disappointed in your statement, Minister, given that they did expect a more substantial, more transformational Crofton Bill to come quite quickly on the back of this technical bill. So it's disappointing to hear that you don't actually have any firm timescales on when to deliver that reform. That's certainly the feeling that we get from stakeholders, that this was just a small step towards more transformational change. Tim Eagle?
Yeah, I mean, I think I was just going to come in on that point, Minister. That was my understanding. Now, I think legal experts have said that the legislation is quite patchwork. It's all over the place. I think Highland Council and Western Isles Council have made comment that there should be root and branch reform of crofting. And I thought, I haven't got it in front of me, I was desperately trying to find it there, but I thought, as a party, the SNP had said that they would do a big reform of the crofting law. And this isn't what this is. So it's not, I think within the consultation responses, there is wide acceptance that this is some good stuff and that we want to see this. But that doesn't take away from the fact that many people in the consultation responses and afterwards, including the Crofting Federation, have said we need bigger root and branch reform of crofting law. So I don't think that's given they've waited years, for how much longer do we need to wait to make sure that crofting is fit for the future?
Well, there were a number of things that got in the way of actually delivering a bigger crofting bill from 2018. I'm not going to go over the history. But I've already said, we absolutely get that there's going to be a bigger crofting bill that's going to have to come down the road. But what we're focusing on right now is making sure we get this one right, make sure that we've got people on board with it. Once this is, I hope, once this bill is passed by this Parliament, then that allows us to then have the bedrock to say, OK, what's next? Because we absolutely know that this is not a final. This is a journey. It's absolutely a journey, and I am very committed to make sure we continue on that journey even after this one is completed.
Move on to section 2, which, with apologies to solicitors, it's probably the more drier part of the legislation. Oh, I'm sorry. We are actually. I can see a relief. I'm going to actually suspend briefly to allow a changeover of witnesses to bring in the lawyers that I've probably just suggested is the dry, less interesting part of the bill. But I'll suspend for 5 minutes. Okay, welcome back. We're now going to move on to part 2 of the Crofting and Scottish Land Court Bill, which relates to the Scottish Land Court and Lands Tribunal Scotland. And joining the Minister from the Scottish Government is Martin Brown, the Solicitor, and joining us remotely is Marion McCormick from the Civil Courts, Justice Transformation and Inquiries. So I'm going to move to a question from... Jim, do you have an opening statement in this section?
I do, Convener.
Thank you, Minister.
And we do have Marion McCormick present as well. Yep, that's lovely. Thank you. And thank you very much again for the opportunity to give evidence on part 2 of the bill, which makes provision for the merger of the Lands Tribunal for Scotland and the Scottish Land Court. This merger creates a one-stop shop for users. It's offering a streamlined process that is clearer and easier to understand and navigate. The rich history of the Land Court dating back to April 1912 and the affection with which it is held, particularly within the Crofting community, is recognised and respected in the bill and is a key reason why the tribunal itself, a respected body with important functions, albeit with a shorter history, will be joining the court. The bill also seeks to preserve the traditional character of the Land Court, and that includes maintaining local sittings and retaining the requirement for a Gaelic-speaking member. Under the new arrangements, the composition of the bench will reflect the specific requirements of each case. There will be no dilution or diminution of expertise. The newly expanded Land Court will retain and indeed strengthen the depth of specialist knowledge that is available. The bill also provides for the expansion of the Land Court's jurisdiction by regulation and on a case-by-case basis. Importantly, ongoing proceedings will not be disrupted by the merger. The provisions have been designed to provide flexibility so that any transitional or implementation matters can be managed smoothly as they arise. And while the Tribunal's jurisdiction and functions will transfer to the Court, the Tribunal itself will not dissolve immediately. Its members will be able to sit in the Court during that transition period, with full integration to follow through separate legislation. Alongside the merger provisions, the bill also enables suitably qualified members of the merged court and, on a transitional basis, members of the Lands Tribunal for Scotland to act in the upper tribunal. So while the provisions are largely administrative, they will enhance the resilience of the upper tribunal by giving it access to a broader range of expertise when required. To ensure this is done appropriately, safeguards are in place involving the chair of the court, the president of the Scottish Tribunals, the Lord President and the members themselves. So in summary, the proposals in Part 2 of the bill will bring practical improvements while safeguarding the proud heritage and expertise of both institutions. They offer continuity where it matters and change where it is needed. And happy to take any questions from the committee as they might have them.
Thank you very much, Minister. And I move to Beatrice Wishart.
Convener. And the policy memorandum doesn't actually explain the Scottish Government's reasons for proposing the merger of the Court and the Tribunal, and the Law Society of Scotland has expressed concerns that the main driver could be to cut costs and reduce capacity. I note you say that this will bring a one-stop shop and there'll be no diminution of expertise. But could you explain what the policy objective is for the merger, and what reassurances can you give that resources and capacity will be maintained?
The policy objective has been that this merger has been talked about for a very, very long time. It has been one that has been looked at by various institutions over the period, and it is to give that streamlined structure to the system as it currently stands. But as I said, it's not going to have any diminution of the ability of the tribunal or the courts. It's actually going to enhance it, and I think that has been welcomed broadly by most people that we have spoken to.
Okay.
Thank you. And the next question from Alistair Allen.
Thank you, Convener. Last time we were taking evidence, we were hearing about concerns that had been raised by Lord Duthie, potentially about how a newly merged court would ensure that it managed its workload fairly. Particularly, I had a conversation about internal appeals and appeal routes. So I wonder if you could say anything more about the appeal routes within the new structure and how that will be managed.
Would you like to pick that up?
Yeah, just the internal appeals point is something that's being looked at following the input from Lord Duthie. I think the current system, the way it's set out in the bill, works well for the land court and keeps the position in place for that, but maybe doesn't sit well enough for what's coming in from the Lands Tribunal. So that's something we're looking at to change, and it's under active consideration as to getting that just right in further amendments potentially.
Okay, thank you.
Okay. Emma Roddick.
Thanks, Convener. Minister, the bill retains the eligibility requirements, including for a Gaelic-speaking member. How important do you feel that that requirement is, particularly given the provisions of this year's Languages Act, which seeks to strengthen and actively promote Gaelic?
I think it's vitally important. When the requirement for a Gaelic-speaking member of the court was first made in statute in 1912, Gaelic speakers had no protection in law. The inclusion of this requirement created an opportunity for Gaelic speakers to use their language of preference in at least one institutional setting of importance to them. And the requirement was also an important recognition of the worth of the language and of its speakers, and it's important that this respect of the language is not lost. The 2020 consultation on the future of the Lands Tribunal and the Land Court gauged opinion on whether the Land Court requires a Gaelic speaker, and the majority of respondents considered it essential for the Land Court to have a Gaelic-speaking member. Many of the stakeholders are in favour of maintaining that Gaelic speaker. Note that many crofters Gaelic is their first language, and this identity has to be acknowledged in order to ensure the civil and human rights are not eroded. So stakeholders have also highlighted there's a close relationship between the Gaelic language, the land and crofting. There is reasoning in the Gaelic language which does not transfer straight across into English, meaning that sometimes an argument can be only properly made in Gaelic, and it requires a Gaelic speaker to fully understand the points. And just from a personal point of view, I think it's a heritage that we should cling on to very dearly.
Hopefully
Despite
Gaelic,
the fact that I can't speak the language myself, and I'd very much like to.
hopefully Gaelic speakers as well. You did mention there are many crofters for whom Gaelic is their first language, and that some turns of phrase, even relating to land rights, might not directly translate. Are there particular situations where this has arisen so far in the court, or is the Minister just generally aware that can be a
I am generally aware, given the fact that I am not a Gael, then I can't give specific answers to that, I'm afraid.
Thanks.
Thank you. Ariane Burgess.
Thanks, Convener. I wanted to take a few minutes to explore the idea of the Land Court also expanding its jurisdiction to an environmental court, and that's been kind of stated in the policy memorandum as something that could be considered in the future. But I just wonder if there is an opportunity, given that Scotland's got an ongoing breach of access to justice requirements under the Aarhus Convention, and that is in part that people can't get access to justice because of the cost of taking forward taking forward litigation. So is there an opportunity here to actually speed that process up and actually get ourselves into, following in line with the requirements? We've been kind of cited by the UN committee, recent updates in 2025 that still describe Scotland as failing to guarantee compliant environmental justice. So is there an opportunity here to explore that and to bring that forward rather than consider it in the future?
Well, the bill provides ministers with the flexibility to adjust the jurisdiction of the Land Court, and it's clear that the new expanded Land Court is primarily within the context of Scottish farming and crofting. It doesn't have universal jurisdiction to deal with all matters relating to land. And when we're talking about complicated environmental cases, it's likely to cover a number of issues such as cultural, social, economic, and as a result should continue to be considered, amongst other issues, through the current courts and tribunal system. The Scottish Government is committed to ensuring that there is effective access to justice on environmental matters in Scotland. Since the UK left the European Union, steps have been taken to strengthen the access to justice in those environmental matters. So we've got the Environmental Standards Scotland. It's an independent body that's been set up to ensure that environmental laws and standards are adhered to in Scotland, replacing the European Union scrutiny and enforcement role. And at the time of the Scottish Government review into the environmental governance, the ESS was a new body, and the Scottish Government acknowledged that time was required to allow the new arrangements to be implemented in full. So under their draft strategy for 26 to 31, the ESS have stated that they will ensure that environmental governance systems work effectively. So I hope that that gives the committee some confidence that there is work actually going on with this.
Yeah, I mean, and I just want to say, my understanding of anything that we're doing here in the government and the parliament is that there's always work going on, and bills are just part of a process to unlock powers, and either to give powers to ministers or to councils or a public body. So I understand that work is ongoing, but this does seem to be somewhat urgent, and I get that we've got Environmental Standards Scotland in place, but we are seeing organisations having to take forward judicial review, which is very costly. And I think what organisations and the UN are looking for is an access to justice that is more affordable.
Well, I don't think at this stage we're looking at this bill. As I said, it's primarily engaged with farming and crofting, and that's the function that has been set out to do at this moment in time. Well,
it's primarily engaged with farming and crofting and land issues, and there's an awful lot of environmental issues that take place on land. It's just worth considering, I think, at this point.
Point taken.
Can I ask, Minister, are you in favour of a standalone environmental court, or do you see in the future that what we have now might change to cover more environmental cases?
Well, as I said, the Environmental Standards Scotland is an independent body that's currently setting out its strategy for 2026 to 2031, and that's the position that we're currently in.
Okay, thank you. Aran, did you have a supplementary?
Yeah, I just wanted to pick up on the convener's question there as well, and we heard from the Land Court last week, and one of the concerns that they pointed to in terms of expanding that jurisdiction would be the resourcing. And I wonder if that's part of the challenge here is a budgetary concern. Do we not have the finances at this point in time to meet our environmental obligations?
That's not a position that I am taking. That's not an answer I'm giving one way or the other. That's not the consideration that I've had. It was purely about what this merger was going to deliver in terms of the crofting regulation. That's where my consideration has been.
Thank you. We've got no further questions, Minister, so thank you and your officials for your time this morning. I now suspend this meeting for a further 5 minutes to allow a changeover in witnesses. Thank you. Welcome back. Our second item on the agenda is an evidence session on the Greyhound Racing Offences Scotland Bill at Stage 1 with Mark Ruskell, the member in charge of the bill. And I welcome Mark to the meeting along with Nick Hawthorne, a senior clerk, Liz Anderson, assistant clerk from the Non-Governmental Bills Unit, and Alison Fraser from Legal Services. We've allocated around an hour and 15 minutes for the discussion, and as always we've got quite a few questions, so I can ask members and members to be succinct with the questions and answers. I would like to invite Mark to give us an opening statement, up to 3 minutes. Thank you.
Thank you very much, Convener. I should declare an interest as well, as I'm an honorary member of the British Veterinary Association. So I introduced the Greyhound Racing Offences Scotland Bill in April this year, and I welcome the Scottish Government's indication that it supports the general principles of the bill. I'd also like to thank the committee for its work looking at this bill and the wider welfare issues of greyhound racing over the last 3 years. The extensive evidence this committee has taken previously helped me to focus this bill on the central concern that racing greyhounds around a track at high speed results in injuries and long-term suffering of the dogs, and in too many cases can lead to their deaths. The evidence points to the numbers, but behind every number is a real dog facing real suffering, and I want us to end that suffering. The bill will make it illegal for someone who owns or is responsible for a greyhound or a racetrack to race or to allow the racing of a greyhound on an oval racetrack in Scotland. The offences set out in the bill apply to greyhound racing at licensed and unlicensed racetracks and cover any racing activity, including time trials and sales trials. The offences cover tracks that are oval in shape. All racetracks in Scotland are oval in shape. This should ensure that no further greyhound racing takes place in Scotland. However, the bill also allows Scottish ministers to regulate to make it illegal to race greyhounds on other types of tracks. Therefore, should a new racecourse be opened with, for example, a straight track, the Scottish Government could extend the offences in the bill to cover that track, should it be deemed to pose a risk to greyhounds. The bill provides that if someone is convicted of an offence, they may be subject to a fine or prison sentence. The court may also impose other penalties. These include preventing someone from owning or keeping a greyhound that was present when the offence was committed, banning someone from owning, keeping or working with a greyhound for a period of time, and taking a greyhound away from someone who has previously banned from owning, keeping or working with a greyhound, but who has continued to do so. The penalties and enforcement powers were based on those set out in existing animal welfare legislation. And I note that in the Scottish Government's memorandum to the committee, it has suggested the enforcement powers be modified. I also note the Scottish Government's suggestion that the bill is amended so that the commencement date of the Act would be determined by Scottish ministers. I am content to work with the Scottish Government to bring forward amendments in all of these areas. So I thank the committee for its work again, Convener, and I'm happy to answer questions.
Thank you very much. Mr Ruskell, can you talk us just through the consultation and engagement you undertook to develop the bill? As you'll be aware, that the committee previously took evidence on a petition to ban greyhound racing, and some part through that, there appeared to be a lack of evidence on or evidence of prosecutions or involvement in SSPCA in animal welfare related to racing. So can you give us an idea how you established an evidence base for prohibiting racing in Scotland?
Yeah, thanks, Convener. Well, I would point to the evidence that this committee has taken. So the 6 evidence sessions that you had, the public call for views on the petition, the Scottish Animal Welfare Commission report, which focused a lot not just on what happens in Scotland, but also reviewed some of the scientific work as well, looking at the inherent risk of racing dogs around oval tracks. I'd also point to the licensing review, which the Scottish Government conducted as well, and all the evidence that comes from that. In terms of the evidence base and the consultation around this members' bill, undertook consultation during 2024. I hope the committee has got some of the evidence on that before it as well, the number of responses. I would point out that there were a number of organisations that gave evidence to that, including Scottish Courts and Tribunal Services, GBGB, Greyhound Board of Great Britain, animal welfare charities. And there were also a number of individuals who race greyhounds in Scotland, who are professionals within the sector who also gave evidence as well. And I would point to the fact that through the consultation as well, what we had was extensive evidence that was given by people who have rehomed greyhounds. I've had dozens and dozens of testimony from those individuals, and I would like to just sort of read out just one or two of the responses that I've had. One of these responses, somebody said, "I've seen the devastating impact that greyhound racing has. These dogs arrive not as dogs, but as traumatised machines. They're scared by the littlest, most common things and don't know how to function in a normal home." Someone else, "My second dog was a rescue. His owner was caught giving the dog high doses of painkillers so he could still race on a badly injured wrist. The injury affected him for the rest of his life, continually swelling and ending up with chronic arthritis." Someone else saying, "I adopted an ex-racing greyhound in 2017. When I adopted him, he looked moth-eaten, very thin, had patches of dandruff all over his coat and an old injury to his hock, which he got while racing. He had bull back legs caused by friction of being forced into traps to race. He had separation anxiety for the remainder of his life. I had to change my job to accommodate his needs." And then a final one. This is difficult reading, I have to say. "I adopted an ex-racer. His body is broken from racing. He has sore legs. Came to me with an amputated tail, a sore back. This hasn't gone away after 4 years. My ex-racer was retired at 2 years old after allegedly only 4 races. His body is broken from it. He takes pain medication every day. His teeth are all worn down from gnawing at the cage he was in kennels, and he has a sore back from being hit. Despite this, he's the most gentle and kind boy." So what the evidence base shows us is that there is an inherent risk of racing a dog at high speed around a curved track. And the implication of that is that the dogs leave the industry when they're very young dogs and they get rehomed. The evidence that we have from the rehomers, I think, is absolutely critical in this. But the committee has had stats from GBGB, it has the empirical evidence, it has the scientific evidence that explains that inherent risk.
I think the evidence you've given in testimony is distressing, but I think what we need to focus on is greyhound racing in Scotland. Of those examples you just gave us, how many of those related to dogs that had been raced in Scotland?
Well, all of these are examples of dogs that have raced on oval tracks, and there will be a mixture of dogs that have come from England, mixture of dogs that have come from Scotland. But the critical point of this bill is it focuses in on that inherent risk of racing a dog around an oval track. All the oval tracks, all the tracks that exist in Scotland are oval in nature. They're the same as the tracks which exist in England as well. And it's that inherent risk, which is well understood, which is well studied, which shows what that risk is and the impact that can then have on the dogs.
But I guess what I'm really pressing at is this is legislation which sets out, quite rightly, to address animal welfare issues in Scotland and prohibiting greyhound racing in Scotland. So it's actually really important that the testimony that you've given us, distressing as it is, that we understand actually accurately how many of those were as a result of them racing on oval tracks in Scotland. Because your bill, with the best intentions, is not going to address the issues around greyhound racing out with Scotland. So it's really important the evidence does absolutely focus on oval racing in Scotland. So do you have of those testimonies you read out, how many were as a result of those dogs racing in Scotland?
Well, the consultation on the bill, we had 789 responses. 86% of those were fully supportive of the proposal to ban greyhound racing in Scotland. And we've had a lot of evidence that's come through, as I said, from the industry, from academics, that focuses on that risk of racing on an oval track. There is lots of evidence this committee has had of the impact.
Sorry, Mark, I'm going to interrupt you because it is really important. I'm not doubting the evidence you've given us, and that there is an inherent risk of dogs racing on oval tracks. But again, this is a bill that will apply in Scotland. So we've got to have a sort of indication of how effective it's going to be, how many dogs are actually going to we're going to protect from racing. So again, of those examples that you've got, how many were actually involving dogs that were injured racing in Scotland? Because, again, with all due respect, those other examples, if it was actually dogs racing south of the border or elsewhere, this bill is not going to bring any animal welfare benefits.
Yeah. So, I mean, what I'd like to highlight then is the Scotland-specific data that I know that the committee has had in the past. And I would point to the figures that were collected at Shawfield Stadium when it was running between 2018 and 2020, and those were produced as a result of it being licensed to GBGB. And, there were, during that period, 197 injuries, 15 fatalities. We know, looking at the injury rate at Shawfield, that it's comparable to every other greyhound racing stadium across the UK. So, where there is that specific data that is available, and I know that a number of these people who've given testimony have taken dogs from Shawfield. They've taken dogs from Thornton as well in the past, as well as dogs from England. Where we have that data, we can see that there is that impact on the dogs, and it is the same impact regardless of whether they're racing in England or Wales, in Scotland, because it's the same inherent risk of being raced on an oval track.
Okay, thank you. Emma Harper.
Thanks, Convener. Good morning to you all. Good morning, Mr Ruskell. It's kind of on the similar vein around independent tracks and looking at the Scottish Animal Welfare Commission's report. They had a couple of summarised points that said that independent tracks, although they may provide some social benefit, do impose risks on dog welfare through the lack of immediate veterinary care to injured dogs and general veterinary oversight. So that was one issue that was raised. And also, the Scottish Animal Welfare Commission suggested or recommended that no further new greyhound tracks are permitted in Scotland. And I know that member just mentioned Shawfield, and I think it's proposed that that will be demolished for housing, so there will be no more racing in Rutherglen. So I'm just interested in issues around the data from independent tracks compared to the GBGB tracks as well. And it's kind of, you've almost basically said it all already based on the Shawfield evidence.
Yeah. I mean, in many ways, the unlicensed track that runs in Scotland at Thornton is an underground track. I mean, it doesn't collect figures. It doesn't report those figures to GBGB. But the nature of that track is it is similar to every other greyhound racing track in Scotland and every other greyhound racing track across the UK. So the inherent risk is still the same. The peer-reviewed scientific evidence shows that there is that inherent risk of racing a dog around an oval track. When the dogs reach the first curve, they face that centrifugal force on their bodies. There's the risk of them colliding as they narrow, the 4 to 6 dogs narrow to chase the lure. There's that impact and injury that they get with their left front leg and their rear right leg. So those injuries don't change depending on whether the track is licensed or unlicensed. The point you raise around whether licensing brings some marginal benefits to animal welfare, well, yes, having a vet at the track side, it would no doubt be beneficial if a dog gets injured, but the purpose of this bill is to prevent that injury from happening at in the first instance. And it's through racing at high speed on those oval tracks that is the reason why these injuries occur.
And the speeds we were hearing last week is it's 40 miles per hour almost. That's like 64 kilometres an hour on the first bend. So it's quite high speeds that can lead to the injuries of the greyhounds.
Yeah. And again, this is what the scientific evidence shows us, that it's the nature of that high-speed race, the fact that greyhounds are very fast and dogs, the forces that are exerted on the dogs, this is what leads to those injuries and deaths. And I think, if members have ever watched a greyhound race, I haven't been to a greyhound racing stadium myself. I've watched many races on television. I've watched many excerpts from races as well. You know, the speed of these dogs is phenomenal, but, you know, they will run. You know, they do enjoy running, and they will run very, very fast to the point where they will injure and potentially kill themselves. So, you know, it is important that, you know, we draw a line under this.
Okay, thanks. Thank you.
Thank you. Beatrice Wishart.
Thanks, Convener. Good morning. The Thornton Greyhound racetrack is thought to have ceased racing activity around the time the bill was introduced. How do you think this impacts on the need for this legislation?
So, currently there are no races that are taking place at Thornton. I don't think there's been any races since March this year. I would, though, point to what may happen in the future, particularly if this bill doesn't go ahead. So I think, you know, you've had evidence from Paul Brignall in this committee with the Call for Views, who is the owner of the Thornton Stadium. And he indicated that if it weren't for the bill and the campaigning around it, that Thornton would now be GBGB licensed. And he said the stadium would have been racing under GBGB rules and providing part of the SIS service to betting sites all over the world, and would have been a thriving business contributing to the Scottish economy. So, you know, the appetite is there from the one remaining greyhound racing stadium in Scotland to actually expand and to actually get GBGB certification, which would mean many more races in Scotland, many more dogs racing, higher frequency of races, more injuries and more deaths. So, yes, there's a situation we're in at the moment where, partly because of the scrutiny of this committee and the proposal for the Members' Bill and the petition, greyhound racing currently does not exist in Scotland. However, the future may look very different. And, you know, I draw attention to the committee that, you know, there is a proposal now which looks like it will go through the Welsh Senedd to end greyhound racing in Wales. And clearly, if that goes through the Senedd and is approved, there may be investors looking to invest in upgrading tracks elsewhere around the UK. And if this bill doesn't go through, they may well look at Scotland and say, we'll invest in Thornton. So, you know, the future is uncertain. The future kind of depends on whether Parliament approves this bill or not.
Thank you.
Thank you. Alistair Allen.
Thank you, Convener. Following on from these questions, I'm aware that the scope of the bill is for banning racing in Scotland, but as I understand it, that's not going to directly affect dogs that are kennelled or trained in Scotland and then sent to race in England. I appreciate it may not be possible for us to legislate on that or practical. I wonder if you could say a bit about that issue or that question that must have been raised during our consultation.
Yeah. Yes, it has been raised, and, you know, particularly by animal welfare charities who would like to see progress with greyhound welfare everywhere in the UK, and would like to see an end to greyhound racing everywhere in the UK and Ireland as well. I mean, I think that, you know, where we've got to with the bill is it's very tightly drawn. It creates a standalone offence of, you know, racing a greyhound or organising a racing of greyhounds in Scotland. It's not possible, obviously, for us in this Parliament to create an offence around racing a greyhound in Swindon or Oxford or in Wales. The issue about dogs that are kennelled and in Scotland and their trainers live in Scotland and are then being taken to races around the UK, that is existing practice. It's something that happens at the moment. I am concerned about some of the welfare implications there, particularly around kennelling, around breeding, around transportation, but that's not within the scope of this bill. There may be a case for the Scottish Government to look at wider licensing. So, for example, animal transport licensing. Is that currently working effectively for racing greyhounds? You know, are local authorities enforcing that? But that's out with the scope of this bill. And I think, member might recall, I did ask that question of the Minister in last week's session. I would like to see the government conduct a wider review, but that review would be outside the scope of the bill, and it may, you know, be a review that could consider, you know, other animals, other breeds of dogs. So it would be perhaps a larger piece of work that the government would need to do. I would note that the Welsh Government has made a commitment alongside their standalone, their bill, which creates a standalone offence of racing a greyhound. They have committed to a wider piece of work to review whether the existing framework in Wales of regulation that relate to racing greyhounds that are crossing the Welsh border. And that is something the Scottish Government could do, but I don't believe it would be within the scope of this bill, which is about creating this narrow offence and giving the courts the enforcement powers on the back of that.
So the scope of the bill wouldn't include, for instance, having a shown intention to transport dogs elsewhere for this purpose?
I don't believe that that would be within the scope of this bill. And I think, the committee would have received the memorandum from the Minister and, can reflect on the Minister's evidence from last week as well. I'm not discounting that there are issues, and there will be probably suffering as well, greyhounds, but that is a wider issue that I think government would need to consider.
Thank you.
Thank you. Emma Roddick.
Thanks, Convener. The SAWC report did highlight that possibility of greyhounds continuing to be owned, bred, trained, kennelled in Scotland for racing in England. So during the call for views, the development of the bill, were there any mechanisms suggested that could curtail that behaviour?
I'd need to reflect on individual submissions, particularly those that have come from animal welfare charities. It has been an area of discussion that we have had. I think there's an understanding from animal welfare charities that this bill does, have a narrow focus. It is focused on that inherent risk of racing a greyhound in Scotland, but there is a wider concern. Again, I think that's a question to the Scottish Government about how they address that concern. I would like to see some progress in that area, but it shouldn't detract from what this bill is trying to achieve, which is first step, absolutely establish an offence of racing a greyhound in Scotland. And I think this has come on the back of the 2006 Animal Welfare Act not being appropriate, not being the 2006 Animal Welfare Act has not been able to address the issues surrounding the racing of greyhounds in Scotland, and that's partly come on the back of the fact that greyhound racing is inherently a lawful activity, so it's been very difficult to prove that there's been unnecessary suffering of greyhounds. So we're at a point now where 2006 Act has really not worked. It's not dealt with that inherent suffering. And therefore, the only way forward I see it is to bring in this offence of racing a greyhound. And my hope is that, other jurisdictions will also, perhaps follow Scotland's lead as well. The Welsh bill is going through the Senate at the moment. There's an active discussion, I know, in Ireland. And of course, there are, countries and states, jurisdictions around the world that, while this committee has been taking evidence, have gone ahead and actually banned greyhound racing. So, there's a direction of travel here. There's an international consensus that creating offence, racing a greyhound, is the right way to go, and I hope that over time, that will result in benefits for all dogs.
Yeah. So you've stated the position that this would be out with the scope of this bill, which is worthwhile doing on its own. But would you be open to pressing the Scottish Government to introduce an accompanying scheme, to introduce a statutory licence requiring any person or premises in Scotland that keeps or trains a greyhound for the purpose of racing anywhere in the UK to have that licence that could maybe allow government to put restrictions on transporting that greyhound out of Scotland to race?
I've not taken evidence on that. So that the conclusion that I came to on the back of the committee's evidence and the work the committee's done on this issue for many years was to create this offence. That has been the focus. I think if there was a wider consideration of that would be a question for the Scottish Government to consider. In terms of what would be within scope of this bill, should it get to stage 2, that's a matter for the convener. But my my view and the view of the Scottish Government is focus on the standalone offence. I'm not discounting the wider issue. And if the member, wishes to discuss further with the Minister or myself, I'd be, content to do it.
That's good to know. I think my concern primarily is the number of ex-racing greyhounds rehomed in Scotland does seem to be, even when there was racing happening in Scotland, a lot higher than the number that were being raced in the country. So there are clearly wider welfare concerns that apply to the same situation that the member is trying to address with this bill. Are there other welfare issues for greyhounds away from the track that you've been looking at and would like to see prioritised for kind of next steps around greyhound welfare?
Well, I point to the committee's excellent report where, you looked at breeding, you looked at the relationship with breeding in Ireland, you looked at, kennelling and other issues. But again, that's out with the scope of this bill. And I think the committee made some very helpful recommendations to the Scottish Government about the kind of work that it would like to see the Scottish Government undertake in relation to those wider concerns. But, this is a member's bill. It is tightly drawn. There are wider animal welfare implications, greyhound racing, but that is a proper matter for the Government to consider in due course about how it addresses those, in my opinion.
Thank you. Ariane Burgess.
Convener, the Emma Roddick's question brought an answer that I was looking for. Thank you.
Okay. I suppose my question is, why didn't you take a different approach to this bill, which would have addressed the wider animal welfare issue? Because currently, this bill, if it's to go through without amendments, which you've suggested would be out with the scope of the bill, no dogs would benefit from it because there is no racing on oval tracks in Scotland. So I wonder why, given that all the evidence that you've given the committee surrounds dogs that are being raced in England. So the bill at the moment, if it was to be successful and goes right through, there'll be no dogs in Scotland that actually benefit from it. So I suppose, why didn't you take a different approach? And why is it so narrow when a lot of the concerns are about dogs racing out with the country, but also there were concerns raised about kennelling, which this bill is not going to address?
Well, I would come back on the point there's no evidence in Scotland. The committee has had evidence of the inherent risk of greyhound racing in Scotland. In terms of the approach, this is a members' bill. I would reiterate the fact that if the committee would, want to examine the issues of licensing and animal transportation licensing, that goes way beyond greyhounds. It probably goes way beyond dogs. It could include other animals as well. So there is a responsibility here for government to look at some of those wider issues. The focus of bringing forward a piece of legislation that creates a standalone offence around racing a greyhound around a track is, I believe, the most appropriate way forward. It's the way forward that the Welsh Government are choosing as well.
I guess I feel this potentially is a missed opportunity because, again, there isn't any racing in ovals in Scotland, but there is still, from the evidence you've given us, an issue with animal welfare relating to dogs racing. Why didn't you consider, as Emma Roddick has suggested, having an element of licensing in there that could cover a lot of these aspects? Because it's so narrow, it is questionable whether, in the absence of any racing in ovals in Scotland, that this will actually deliver anything. And you're saying it's the government's responsibility, but this was a fantastic opportunity to address the majority of the animal welfare issues that you've used in evidence to support your bill.
Well, I go back to what I said earlier and the evidence the committee's had from the owner of Thornton. The owner of Thornton would like to start racing again. would like to expand racing in Scotland. So I don't think it's a given that there are no dogs that will ever race again in Scotland anyway, even if the bill doesn't go through. I think actually the reverse might be the case. And the evidence you've had from the committee, from the person that is running the last remaining Greyhound Stadium in Scotland, suggests that that is the case. I mean, I think with those wider issues, that is a matter for other jurisdictions around the UK. You know, there is a bill going through in Wales. You know, there is a discussion taking place at Westminster as well. Ultimately, the only way to really deal with the welfare issues in relation to greyhounds is to see an end to greyhound racing. Any kind of introduction of licensing will not bring those benefits. It will not tackle the inherent risk. So, you know, with the figures that we have, which come from the licensed industry, it doesn't show an improving picture. It hasn't shown an improving picture over the years that that data has been gathered. And despite the attempts of the licensed industry to bring in a better welfare strategy for greyhounds in 2022, despite the introduction of new standards over track maintenance, it hasn't fundamentally shifted the picture. Within the licensed sector, which is now highly licensed, we're still seeing dogs injured. We're still seeing dogs killed. I believe the figures for the last year showed the number of deaths have actually gone up. So, you know, I don't see licensing as a way forward that will tackle that inherent risk. I think the Scottish Government has come to the same conclusion on the back of the SORC report, on the back of looking again at the evidence and what has been coming through in terms of the numbers. Licensing has not worked. I think if licensing had worked and we were looking at no injuries or hardly any injuries and deaths, this would be a different conversation. But I think all the animal welfare charities, the Scottish Government, SORC, are all centring around this same conclusion, which is that licensing has not delivered that impact. So to suggest that actually we need to go back and kind of create some bespoke licensing provision and that might help the dogs in some way, well, it hasn't worked up to now, and it certainly won't deal with the fundamental numbers of dogs that are being killed and injured.
Okay, thank you. I'm going to now move on to the section 1 and 2 on offences and penalties, and questions from Tim Eagle.
Thank you, Convener, and good morning, Mark. So just a couple of quick questions. One, the first is, the approach you've taken in the bill is to criminalise both the track owner and the individual racing their greyhound. Now, that's quite different to the Welsh bill, which is focused more around the greyhound racing venue and those organising greyhound racing. Can you just explain a little bit more about why you've taken that approach in your bill?
Okay, so we've taken that approach because we believe it's more comprehensive. We don't want to get into a situation where we create a loophole where the owner of the track could be penalised, but those actually racing the dogs, putting the dogs in the traps, actually providing the dogs, are not also included. So I believe that's a more thorough approach to it.
Okay. And the second question was just around the maximum penalties that you've put within the bill. So we heard from the Minister last week that they are in line with the Animal Health and Welfare Scotland Act 2006. Is that how you, when you were looking at the penalties, is that how you looked at them? And can you just talk about how that compares with what's been put in under the Welsh bill?
Yeah, so those penalties do derive from the 2006 Act. I mean, this is obviously legislation that we've had now in operation for nearly 20 years. The courts are very used to applying, those penalties as appropriate. They are, of course, maximum penalties that would be available. So there's existing legal provision there. In terms of the decisions in the Senate, I mean, I just note that, there's a different devolution settlement and, Scots law applies in Scotland. I think English law applies in England. So, we have Scots law within our jurisdiction. We can adjust criminal penalties within this Parliament. So that may explain some of the differences in approach. I may ask Nick potentially to come in if there's additional detail.
Thanks, Mark. Yeah, no, wouldn't add much to that, only to say that yes, the penalties in this bill match those in Part 2 of the Animal Health and Welfare Scotland Act, chosen because they were in line with that and other animal welfare legislation. In terms of the Welsh bill, as you remarked, Mr Eagle, there's different offence there. They haven't got the offence applying to the owner of the greyhound, which may account for some of the differences in the penalties. But yeah, the Scottish Bill set against a different legal system, so we'd expect there to be some differences in some of these details.
Have you reflected on why, because imprisonment isn't in the Welsh Bill, but it is in yours. Have you reflected on whether you think that's absolutely necessary?
It is in line with the 2006
With the 2006 Act, but in terms of a more bespoke model, is that something you would consider taking away?
Well, I would come back to that fundamental point, which is that this Parliament is concerned with Scots law, and the Welsh Senedd, I don't believe, has the ability to apply those kind of penalties because they're applying English law.
Yeah. Okay, fine.
Ariane Burgess.
Thanks, Convener. We're talking about here about bringing in penalties, and I just wonder why there's a need for that. Why doesn't self-regulation work?
Well, self-regulation is the system that we have at the moment. I mean, where there are licensed tracks, they have a set of rules. They're responsible for enforcement of those. But the data from the licensed sector shows that inherent risk isn't going down. Dogs are continuing to be killed. Dogs are continuing to be injured. I mean, there are examples of where trainers have fallen foul, I think, of GBGB rules and have been struck off. But this doesn't affect the fundamental picture here of the numbers of dogs that are being injured and killed. And there are examples of where GBGB trainers have been found to be abusing animals, quite frankly, and it's taken a long time for those trainers to have their licenses revoked. And again, we've had evidence of that coming through the consultation. There was a dog, I think, connected with Shorefield. So there you go, Scottish evidence. A dog connected with Shorefield called Dudley's Forever, where a steward, I think, at Shorefield had uncovered this dog in an absolutely dreadful state and had been reported. And it had taken a long time, I think, to then bring an inquiry and for the trainer to be effectively struck off. But the dog had to be put down, and it was half the weight that it should have been. It was in an absolutely dreadful state, and again, it was very difficult, I think, in that case, for the Crown Office to bring forward a prosecution of unnecessary suffering. So I think this all comes back to the fact that licensing is not working. If licensing was working, would I be here today? I'm not sure. But licensing is not working, and this is why it builds the case for the bill.
Okay. Can I just... so earlier, my colleague Beatrice Fisher, I think, asked the question, made the point that Thornton's isn't racing. Yeah. And you came back and you made the point that partly we have evidence in the call for views that in part because of the work that this committee is doing and your work, that's potentially why they're not so busy at the moment, but that there's a view from the owner to actually move towards a more GBGB approach. But I'm hearing from you that if that happened, that actually we can't really have confidence in the Greyhound Board of Great Britain really actually regulating and doing a good job, given what you've said around what happened at the other track.
Well, I would point actually to what happened again in Wales, where you had an unlicensed track. It was the last track in Wales. It was an unlicensed track. It sought investment. It registered with GBGB, and as a result of that, started televising races around the world. The numbers of races went up, the numbers of dogs involved went up, the number of injuries and deaths went up as a result. So, now that may change now if Welsh Senedd approves a bill to end greyhound racing in Wales, but if we don't approve this bill here, the same could happen. The last remaining unlicensed track could get licensed. And I don't see, on the basis of the figures that come from GBGB themselves, that that's going to lead to a welfare improvement. In fact, if anything, it could result in more dogs being raced, more dogs dying, more dogs being injured. So this is the risk that exists.
Okay, thank you.
Okay, we're now going to move on to questions on the definition of a racetrack as oval. Questions from Beatrice Wishart.
Thanks, Convener. The key area where there was some disagreement between animal welfare groups in our targeted call for views was around restricting the ban to oval racetracks. And Dogs Trust, for example, said this might be a loophole. What's your response to that concern, and are you still confident that this is the correct approach?
So, oval tracks, and that word that's in the bill, defines every single track that exists in Scotland, every single track that exists in the UK, every track that exists in Europe. In fact, there are only, I think, 3 straight tracks in the world. 2 of them are in Australia. 1 of them is in New Zealand, and that will close shortly because the New Zealand government are legislating against greyhound racing. So, you know, the fact is that the industry and the act of greyhound racing is on an oval track. Now, is it possible that some other form of greyhound racing may emerge in the future? What are the welfare implications of that? It's unknown. All we know is that straight tracks don't exist at the moment. I think what I've been, you know, focused on, and I have actually taken the views of GBGB into account here, is that, you know, that this bill does need to be future-proofed, and if there are examples of other types of track racing that emerge in the future, it's important that there's a provision within the bill for ministers to be able to reflect on the evidence and change the definition of the track, should that be necessary, should there be an implication in terms of the welfare of greyhounds. So I think what we have in the bill at the moment is proportionate. It reflects the reality of how greyhound racing happens pretty much everywhere across the world right now. Is there a risk of straight tracks emerging? These dogs run fast. You would need a very long track. You'd need investment in a stadium. You'd need a complete, you know, reconfiguration of the way that greyhound racing operates in the UK. I think when GBGB and trainers were in front of this committee some time ago, a number of questions were asked about straight tracks, and it really wasn't clear at all that this was in any way where the industry might go. But if there is a move towards another type of racing or another type of track configuration, the power is within the bill for the government to take a proportionate approach, look at the evidence, and then propose to Parliament through secondary legislation that definition be changed. And I know that, you know, DPLR have looked at that provision in the bill for amending regulations and are content with it.
Thank you.
Just on that, so New Zealand are legislating against greyhound racing completely, but this bill specifically says oval. Now, we know that oval racing doesn't take place in Scotland at the moment, and you're saying, well, but we need to legislate in case it happens in the future. Straight tracks don't exist in Scotland at the moment. So why didn't you just go for a ban on greyhound racing full stop? Was it because it was unlikely the Scottish Government would have supported your bill in that instance?
Well, I would refer back to the work of this committee. I mean, you commissioned the report from SORC. You know, SORC reflected the scientific evidence. The scientific evidence reflected the inherent risk of dogs racing around an oval track. What happens on that first curve? You know, the centrifugal forces, the way that the dogs kind of collide and get congested. You know, at that first turn, and the injuries and deaths that occur as a result. So, you know, I've endeavoured to bring forward an evidence-based bill that reflects the evidence that this committee has had. And I have to say, you know, that thinking has evolved as the committee's taken evidence over time. There is that potential to go further and to have a much more all-encompassing definition of a track should the need arise. But I don't see the need to put that into primary legislation, because I believe that this legislation needs to follow the evidence, and the evidence that you've had and I've had is about oval tracks, is about that inherent risk, and that's the starting point.
I suppose my question kind of roots in the fact that the Minister was unable to tell us what changed in the government's position, because the evidence he gave us as part of the petition really hasn't changed very much. In fact, it might only be a tiny bit better, but actually the statistics over the intervening period had actually improved. But the government still decided to go for a ban. So I guess where it's coming from is you're talking about it being evidence-based, but the government changed their view on oval racing without the evidence to suggest that they should have changed their opinion. And I just, it's whether you considered...
I noted your questions last week, Convener. I mean, all I would say is that I think the government's had time to reflect on the evidence, and clearly, you know, SORC advises to the government as well. I think in the memorandum that the committee's had back from the Minister, you know, the Minister and his officials have very much underlined the key parts of evidence that SORC raised in relation to that inherent risk and the scientific basis for it. So I do note as well, the Minister said last week that despite some, you know, earlier scepticism, they did keep an open mind on the bill and said that, you know, they would wait to see what was brought forward. I have now brought forward a bill. I do believe it reflects the evidence, and yeah, I'm grateful for the fact that the Scottish Government has reconsidered the evidence and has now moved from a neutral position to supporting the general principles of the bill.
Okay, thank you. Going to move on to a question from Rhoda Grant.
Yeah, and it just follows on from that, because as we heard before, the Scottish Animal Welfare Commission has taken a different view. They believe that all greyhound racetracks should be banned. And I wonder if you've spoken to them, have you engaged with them? Do you understand why they took a different view, and has that not changed your mind?
I mean, I have engaged with SORC. I think it's fair to say they see their role as advising government rather than individual members, but I've certainly reflected on their you know, previous report, and I've reflected on, you know, their recommendations as well. I mean, this bill does directly address a number of the recommendations. You know, particularly the recommendation that they came to, that they don't believe that there should be more tracks in Scotland, that tracks should reopen. So, you know, that central concern is addressed with this bill.
But is it, I mean, what they're very clear about is no tracks. What your bill is talking about is oval tracks.
I mean, their evidence with their report, which was provided to the committee, very much focused on the inherent risk of oval tracks, and this bill will end the operation and the racing of dogs on oval tracks.
Thank you. We're going to move on to enforcement provisions, and a question from Alistair Allen.
I was just interested to know about the powers that exist in the bill with relation to deprivation and disqualification, and also seizing of animals. I'm interested to know how they would actually work, and my understanding is that, well, as opposed to, I suppose, how they work in the Hunting with Dogs Act, where there are kind of analogous powers mentioned. So what are the differences and how would it work?
Yeah. So I felt it was important to put these powers into the bill, and that is a difference with the Welsh bill, because, you know, if somebody's creating an offence under this bill and they're racing dogs around a racetrack, that does raise questions about the welfare of those dogs, and I believe it is appropriate for the courts to have at their disposal the option of disqualifying somebody from you know, working with a dog or owning a dog, and for there to be powers of seizure in relation to that. I might bring in Nick, if that's okay, just to kind of go into some of the basis for where those provisions come from and how that relates to the two pieces of legislation that you raised, Dr.
Allen. Thanks, yes. Yeah, in terms of those court order powers, obviously Mr Ruskell wanted to ensure that the offence provisions were properly enforced. Mr Ruskell took a decision that he wanted the courts to have at their disposal the option of making these orders. They are consistent with similar order-making powers in the Animal Health and Welfare Act of 2006 and the Hunting with Dogs Act 2023. And I think my understanding certainly is that the provisions in the Hunting with Dogs Act are in themselves based on the provisions in the 2006 Act, but tailored for that specific offences in the 2023 Act. So similarly here in this bill, those powers are very much based on those two other pieces of legislation, but again, tailored to the specifics of the offences created. So, for example, There may be things in the 2023 provisions relating to hunting with dogs, for concealment of carcasses, or applying to all breeds of dog, things like that. So the provisions in this bill are specific to the offences that Mr Ruskell's bill creates, which is why there might be some slight differences. But ultimately, they're consistent with the provisions in those other two pieces of legislation. And of course, it will be for the courts to decide whether to use any of those order-making powers.
So it would require the courts to make an order before a dog could be taken from its owner?
It's for the courts to determine, yes, whether they want to make an order. And in terms of deprivation, obviously that would relate to depriving a person. There may be reasons that the court determines that would be appropriate. Disqualification, to disqualify somebody, and the seizure order powers only relate to a breach of a disqualification order. So that's where they come in.
Okay, thank you.
Thank you. Emma Harper.
Thanks, Convener. Last week, regarding enforcement responsibilities, indicated to the committee that you were in discussions with COSLA about potentially amending the bill to allocate enforcement powers or responsibilities to local authorities. In addition to Police Scotland, who would have the sole responsibility for enforcement of the bill as introduced. Are you able to provide an update on that?
Yes, and I have accepted, the minister's kind of approach to amendments at stage 2. I have contacted COSLA, and I've been in early discussions with the SSPCA as well. And I would look to, conclude those discussions ahead of stage 2, assuming the bill gets to stage 2. I'm mindful of the fact that there are resourcing issues, particularly I understand with the SSPCA right now. But the kind of provisions within the bill are related to greyhound racing. There is one stadium, one greyhound racing track at the moment in Scotland. I don't see the enforcement provisions as being particularly onerous on inspectors or Police Scotland constables under this bill. So there is a conversation that is continuing with both COSLA and the SSPCA, and hopefully we'll be able to conclude a way forward ahead of stage 2 if we get there.
Okay, thanks.
Is this really a big issue? You can't really hide a oval greyhound track. Is it really a resourcing issue? Is it not the case if somebody reports that there's greyhound racing on an oval somewhere that it's not going to be a big burden surely on local authorities or the police to ensure it doesn't happen?
I can't see it, Convener. I really can't. I mean, if somebody wanted to try and race greyhounds around a barn, for example, that just wouldn't work. So I'm not sure how you hide it. I mean, these tracks are hundreds of meters long. I mean, you can see them from space. So I'm not sure how effectively greyhound racing would go underground to the point that it can't be detected. I mean, clearly both the SSPCA inspectors and local authority inspectors have existing duties under the 2006 Act, so they can go in and they can investigate unnecessary suffering alongside the police if that was appropriate within a particular incident. So, they would probably, if a situation arose, already kind of be there. To look at those wider aspects of animal welfare and whether the 2006 Act was being breached. So I think they would be in the mix anyway if there was an investigation. It would be the police, I think, primarily who would probably take responsibility for seeing who's organising the race, who's racing the dogs, and then for other inspectors to look at any wider welfare impacts. But, to bring it closer to 2006 Act, I've acknowledged the position that the government and officials have come to, and I think if there was a way to make that neater with the existing powers of inspectors, then I'm open to that. But
thank you. Finally, we're going to move on to implementation, transition and review, and a question from Rhoda Grant.
Thank you. The policy memorandum sets out thoughts on transition and what would be envisaged. But given that racing has now further wound up at Thorntons, what now do you think the transitional arrangements would need to be, and what support would be available for the owners and employees of the track?
Yeah. So, I mean, I note that for the time being, racing is not happening at Thornton. We understand through company records that there were, 2 full-time equivalent employees that were based at Thornton. It's not clear whether those employees are still working, given that there is no greyhound racing taking place at Thornton. I think the biggest implication will be in terms of dogs. I know evidence from Scottish Greyhound Sanctuary who've said that they've already taken, I think, the last 3 dogs who raced at Thornton into their care. When Shorefield shut, animal charities, including Dogs Trust, managed to successfully rehome all the dogs from Shorefield as well. I think they have now all been successfully rehomed finally. So I think in terms of transition, the biggest issue is in terms of the dogs, in terms of the future of the owner's aspirations for the asset he has at Thornton. I mean, that's a private matter, a private consideration. I know that there has been reports done looking at the potential for housing in the area. There's a report done looking at the suitability of the site for housing and what the economic investment that could bring to Fife and the kind of jobs that could be created. And, I know that's a live discussion with Thornton Community Council in the sense that they have a local place plan and there's housing allocations. So these are private matters for what happens after. But, what the situation we have right now is that Thornton is not operational. There is nothing happening. One of the reasons why races stopped alongside the campaigns and the evidence taking around this bill is that the bookie retired.
Okay. But have you, given they're the only track that is going to be impacted by this legislation, have you sat down and spoken to them? Have you spoken to kind of local enterprise companies? Have you tried to get, I guess, some support there for them, given that this is their business that's closing down? Have you had those discussions?
Well, I have had some. I have met Paul Brignall, particularly when he came to committee. I have had some correspondence received from him. I think the tone of some of that correspondence is a little difficult in terms of opening up a constructive conversation. I do think that the work that was done looking at an alternative use of the Thornton Stadium and the economic impact that could bring, I think, is a useful piece of information. It was certainly not part of, the evidence that I brought forward within this bill. Nick, I don't know if I could ask you to say a little bit about what's in the financial memorandum in terms of the costs of implementation of the bill and how that relates to the question. If that's okay.
Thank you. Yes. Yeah, it was just to point out that in the financial memorandum does look at costs on other bodies, individuals and businesses, and paragraphs 27 to 29 acknowledge and try to set out some of the potential impacts on Thornton Greyhounds specifically to set out what they might be in terms of full-time staff and potential economic impacts. And then also just to note in relation to what Mr Ruskell was saying that there's some information on potential savings, page 9, which deals with the economic impact assessment report that was made on Thornton Greyhounds Alternative Uses report. So there's a link to that report in that part of the financial memorandum as well, in case that's helpful.
But that wouldn't impact on the staff. The owner could possibly recoup losses through the sale, but that wouldn't.
Yes, in terms of the staff impacts, as I say, have been acknowledged in the and set out to the extent that we understood them to be, and they were taken from published company accounts from Thornton Greyhounds, and also reports, evidence that Thornton's Greyhounds have made to this committee about its level of staffing. But as Mr Ruskell said, the understanding at the moment was that there isn't any racing happening and that arrangements may already possibly even have been made in terms of the staff.
They may already have been sacked.
Well, I think the staff were part-time staff and probably running the facility in terms of bars and other facilities at the venue. But if the Greyhound track isn't open and hasn't been open for some time.
Okay.
Okay, question from Beatrice Wishart.
Thanks, Convener. We know that Thorntons isn't operating at the moment, and we heard from the Scottish Greyhound Sanctuary that there's a rehoming crisis, and despite the lack of racing in Scotland, it's not reduced the number of greyhounds. So, and inferred that it was related to the churn of dogs still coming in from Ireland. So, do you consider there's a need for more support in the rehoming sector in Scotland in general? And did you think that your bill could do anything to support that rehoming sector?
I don't want to see rehoming of greyhounds that have had to be rescued from the industry because they've been damaged and they're facing trauma. I want to end that, and I think those working in the greyhound rehoming sector want to end greyhound racing as well. They don't want the problem of having dozens of dogs. Let's face it, the majority of those are coming from England, where there's, I think, around 490 trainers that are racing dogs. They don't want to have to deal with that trauma. They don't want to have to deal with the rehabilitation of dogs, the extensive veterinary treatment that's required. So if there is a rehoming crisis, and I believe that there is one, it's one which is being driven across the UK by the numbers of dogs that are being wasted month in, month out. You know, young dogs at the prime of their life that are facing these kind of injuries. And I read out a testimony from those individuals who've rehomed greyhounds. I've got lived experience of doing that myself, and their testimony very much accords with my personal experience. So the way to tackle the rehoming crisis is to end greyhound racing and end that inherent risk. And that's what this bill does in Scotland. It's what the Welsh bill will do in Wales. It's for other jurisdictions to consider, as jurisdictions around the world have, about whether they want to continue this, whether they want to continue that number of dogs that are coming through week in, week out. And it is heartbreaking. You see these charities, trying to find forever homes for these dogs. And there's just so many of them. There's just so many of them. So I think fundamentally the way to address the rehoming crisis is to end the need for rehoming greyhounds.
Thank you.
Thank you. Tim Eagle.
Yeah, so I think actually this has been partly answered by an earlier question, but I was going to ask a question on Greyhound Board of Great Britain, sort of suggesting to us that actually it would be driven underground, and I think you've partly touched on that. I don't know if we touched fully, though, on the risk of this moving to other types of racing or other breeds. So I just wondered if you had any other comments around any of that.
I don't see any evidence of that. I mean, there hasn't been greyhound racing in Scotland now for some time. I see no evidence of other types of racing emerging as a result of that. But clearly that would be something for the government and charities and others to continue to review to see if there's any kind of displacement. But it's not something that I've heard evidence of. I don't remember this committee ever hearing substantial evidence of that. But clearly we need to be alive to that. And I think the provision within the bill to alter the definition of the track is perhaps the way to address that. I think GBGB's comments are important, and I think I have considered that issue around undergrounding, and that's partly where that provision in the bill comes from around definition of the track. Because if some other unknown form of unregulated greyhound racing emerges, then clearly this Parliament and ministers and charities and those with an interest in animal welfare would want to be alive to that, alive to what the impacts are. And at that point, the case for amending this legislation would be there. And there's a mechanism through statutory instrument for the government to be able to do that.
Yeah. And do you think then, I mean, I'm taking that into account, but do you think anything else needs to be in the bill that would just monitor that and give an option to make changes if needed?
I'm not convinced of the case for that.
No, okay.
Thank you. This is probably a technical question. Mr Ruskell, you were quite clear that this bill has got a tight and focused scope. And some of the suggestions that committee members had that there might be other things that could be in the bill, you were quite clear that they would be out with the scope. So it's maybe one for Alison Fraser. Obviously, the convener has got to make some decisions about what's within scope of the bill and out with scope. this is probably not particularly contentious, but if you look at other bills like Natural Environment Bill coming up, the decision going to have to be made in that. But can you maybe set out exactly what the legal implications of ruling what is within scope and out of scope of this bill, and what amendments relating to kennelling or licensing that might come forward, or indeed racing on other tracks other than oval tracks, would they be deemed from a legal advice perspective as within scope or out with scope of this bill, given its tight focus?
Well, ultimately, the decision on scope is for the convener, and you're advised, I understand, by the legislation team. So it's not something that we would advise on as such. So it would be improper for me to take that role from legislation team. They would advise you. But I can say, if you look at the long title of the bill, an Act of the Scottish Parliament to make provision prohibiting the racing of greyhounds on racetracks, full stop. It doesn't say. Quite often long titles will have "and related purposes," or they'll have a wider long title. That's a very short and succinct long title. So, but the proper course would be for legislation to advise yourself, convener.
Thank you very much. That's helpful. I don't believe we've got any further questions, so can I thank Mr Ruskell and those supporting you this morning and giving evidence. We now move into private session and I suspend this meeting.